Slide 9. Year 3, Semester 2, Practical Legal Skills. Course, Law.308, Legal History. Foundations of Legal History, Methodology, Sources, and Purpose. 1.1 Why study legal history? Continuity, change, and context. Legal history is not merely an antiquarian pursuit, it is essential for understanding the evolution of legal doctrines, institutions, and reasoning. By examining how laws developed, students gain insight into why current rules exist, how they might change, and what values they reflect. Legal history reveals the contingent nature of law, showing that what seems inevitable today was once contested, and equips lawyers to argue for reform by drawing on historical precedents. Real-life example, the development of the reasonable person standard in tort law illustrates how historical context shapes doctrine. In Vaughan v. Menlove, 1837, the English court rejected a subjective standard for negligence, establishing an objective, reasonable person test. This shift reflected industrialization's need for predictable liability rules. Understanding this history helps lawyers argue for or against modifying the standard in modern contexts, e.g., AI liability. Practical application: lawyers use historical analysis to interpret statutes, original meaning debates, challenge precedents, showing outdated foundations, and advocate for reform, citing successful historical changes. Students practice tracing doctrinal evolution through case law and legislative history. They analyze how social, economic, and political forces shaped legal outcomes. 1.2 Sources and methods, archives, cases, and comparative approaches. Legal historians rely on diverse sources, court records, statutes, treatises, letters, and material culture. Methodologies include doctrinal analysis, tracking legal concepts, social history, law's impact on society, and comparative history, cross-jurisdictional patterns. Real-life example, the Selden Society publications in England have edited historical legal manuscripts, enabling scholars to study medieval plea rolls. In the U.S., the Legal History Review publishes research using archival methods. Comparative studies, like comparing common law and civil law development, reveal path dependencies. Practical application: lawyers conducting historical research for litigation, e.g., original public meaning in constitutional cases, must locate and interpret primary sources. Students practice archival research, case briefing historical decisions, and comparing legal traditions. They learn to evaluate source reliability and contextualize findings. 1.3 Periodization and themes: ancient, medieval, modern, and contemporary. Legal history is often divided into periods with distinct characteristics. Ancient law, Mesopotamia, Rome, established foundational concepts. Medieval law, canon, feudal, blended religious and secular authority. Modern law, Enlightenment, codification, emphasized rationality and rights. Contemporary law addresses globalization and technology. Real-life example: Roman law's corpus juris civilis influenced civil law systems worldwide. The Magna Carta, 1215, established limits on royal power, inspiring constitutionalism. The Napoleonic Code, 1804, standardized civil law across Europe. Each period's innovations built on prior developments. Practical application: lawyers draw on historical themes to frame arguments, e.g., invoking Magna Carta for due process. Students analyze period-specific doctrines and their modern legacies. They study how historical events, wars, revolutions, transformed legal systems. 2. Historical development of common law and civil law traditions. 2.1 Origins of common law, writs, courts, and precedent. Common law emerged in medieval England through royal courts and writs. The writ system provided standardized forms of action. Courts developed precedent through reported decisions. Jury trials and adversarial procedure became hallmarks. Real-life example: the writ of trespass evolved into modern tort law. In Ashby v. White, 1703, the court recognized a right to vote, expanding common law remedies. Precedent created consistency but also rigidity, leading to equity's development. Practical application. Lawyers practicing in common law jurisdictions must understand writ history to interpret modern pleading rules. Students analyze historical cases to see doctrine formation. They study the role of law reports in precedent. 2.2 Civil Law Codification, Roman Roots and National Codes. Civil law traces to Roman law, revived in medieval universities. Codification movements, e.g., Napoleonic Code, systematized law into comprehensive statutes. Scholars' commentaries guide interpretation. Real-life example, the German Civil Code, BGB, 1900, influenced many jurisdictions. Its abstract, systematic structure contrasts with common law's case-based approach. Codification aimed to make law accessible and certain. Practical application. Lawyers in civil law systems rely on codes and scholarly works. Students compare code interpretation with common law reasoning. They study how codification affects legal change. 2.3 Convergence and divergence, globalization and hybrid systems. Globalization has led to convergence, e.g., commercial law harmonization, but also divergence, cultural resistance. Mixed systems, e.g., Louisiana, South Africa, blend traditions. Real-life example, the UN Convention on Contracts for the International Sale of Goods, CISG, harmonizes sales law across common and civil law systems. However, family law remains culturally specific. Practical application. Lawyers in transnational practice navigate hybrid systems. Students analyze convergence drivers, trade, human rights, and divergence factors, culture, politics. 3. Legal history of rights, reform, and revolution. 3.1 Constitutionalism and rights, from Magna Carta to modern bills. Constitutional history traces limits on power and rights protection. Magna Carta, 1215, began this tradition. Enlightenment thinkers, Locke, Montesquieu, influenced constitutional design. Modern bills of rights enumerate protections. Real-life example, the U.S. Bill of Rights, 1791, drew on English rights traditions. Incorporation doctrine applied these to states via the 14th Amendment. Historical analysis informs originalism debates. Practical application. Lawyers argue constitutional cases using historical sources. Students study ratification debates and amendment processes. They analyze rights expansion over time. 3.2 Social reform movements, abolition, suffrage, and labor. Legal change often follows social movements. Abolitionism ended slavery through constitutional amendment and legislation. Suffrage movements secured voting rights. Labor movements achieved workplace protections. Real-life example, the 13th Amendment, 1865, abolished slavery, but Jim Crow laws required further civil rights legislation. The 19th Amendment, 1920, granted women's suffrage after decades of activism. Practical application. Lawyers advocate for reform by drawing on movement strategies. Students analyze litigation tactics, e.g., NAACP's incremental approach. They study backlash and consolidation. 3.3 Revolutions and legal transformation, American, French, and beyond. Revolutions often produce legal overhaul. The American Revolution created a federal system. The French Revolution led to codification. Post-colonial revolutions established new legal orders. Real-life example, the French Revolution's Declaration of the Rights of Man influenced human rights law. Post-apartheid South Africa's constitution blended international norms with local needs. Practical application. Lawyers in transitional societies navigate legal transformation. Students study revolutionary legal texts and implementation challenges. 4. Contemporary relevance and professional preparation. 4.1 Legal history in practice, originalism, precedent, and reform. Historical analysis is central to legal practice. Originalist judges consult history to interpret constitutions. Lawyers challenge precedents by showing historical errors. Reformers cite historical successes. Real-life example, in District of Columbia v. Heller, 2008, the Supreme Court used historical analysis to interpret the Second Amendment. Dissenting opinions contested the historical narrative. Practical application, lawyers research historical sources for briefs. Students practice originalist and living constitutionalist arguments. They analyze how history shapes judicial reasoning. 4.2 Teaching and communicating legal history. Legal professionals must communicate historical insights to judges, clients, and the public. This requires translating academic research into persuasive narratives. Real-life example, amicus briefs in landmark cases often include historical sections. Public interest lawyers use history to educate communities about rights. Practical application, students practice writing historical narratives for legal audiences. They learn to select relevant facts and avoid anachronism. 4.3 Learning outcomes and competency benchmarks. By completing legal history, students should be able to trace doctrinal evolution through historical sources. Analyze the impact of social, political, and economic forces on law. Use historical arguments in legal practice. Compare legal traditions across time and space. Practical application, these outcomes enhance interpretive skills and advocacy. Students should master historical research methods. 4.4 Assessment methods, research papers, case analyses, and presentations. Assessments include research papers, investigate a doctrinal history. Case analyses, brief historical decisions. Presentations, communicate historical findings. Real-life example, a final project might trace the history of a modern doctrine, e.g., privacy, from ancient roots to contemporary law. This mirrors scholarly legal work. Practical application, students should practice historical argumentation and communication. 4.5 Transition to advanced courses, legal history foundations for constitutional and comparative law. Legal history underpins advanced study. Advanced courses, constitutional law, comparative law build on historical understanding. Practice, historical awareness enriches all legal practice. Practical application, students should view history as a tool for understanding and change. Mastery ensures deeper legal insight. Slide 9. Year 3, Semester 2, Practical Legal Skills. Course, Law.309, Negotiation Skills. Foundations of Negotiation, Theory, Strategy, and Ethics. 1.1 The nature of negotiation, interests, positions, and alternatives. Negotiation is a process of joint decision-making where parties with interdependent interests seek agreement. Understanding the distinction between positions, stated demands, and interests, underlying needs, is fundamental. The best alternative to a negotiated agreement, BATNA, determines leverage. Real-life example, in labor negotiations, a union's position might be a 10% wage increase, but its interest is job security and fair compensation. Management's position might be a 2% cap, but its interest is profitability. Identifying shared interests, e.g., company survival, can lead to creative solutions like profit sharing. Practical application, lawyers prepare for negotiation by identifying client interests, assessing BATNAs, and brainstorming options. Students practice interest-based bargaining in simulations. They learn to separate people from problems. 1.2 Distributive versus integrative negotiation, claiming and creating value. Negotiation strategies vary based on context. Distributive negotiation, zero-sum, focuses on claiming value from a fixed pie. Integrative negotiation, win-win, expands the pie through trade-offs and creative solutions. Real-life example, in a real estate deal, distributive tactics involve haggling over price. Integrative tactics might include adjusting closing dates, including furnishings, or offering seller financing to meet both parties' needs. Practical application, lawyers assess whether a negotiation is distributive or integrative and choose strategies accordingly. Students practice value creation techniques like log rolling, trading issues of different importance. 1.3 Ethical boundaries, truthfulness, confidentiality, and good faith. Negotiation ethics balance advocacy with honesty. Lawyers must not make false statements of material fact but may engage in puffery. Confidentiality obligations limit information sharing. Good faith requires genuine effort to reach agreement. Real-life example, in re-disciplinary proceeding against Smith, hypothetical, a lawyer who lied about a settlement deadline faced sanctions. However, stating a client's willingness to settle is generally permissible even if the client is reluctant. Practical application, lawyers advise clients on ethical negotiation conduct. Students analyze ethical dilemmas in case studies. They practice maintaining integrity while advocating zealously. 2. Negotiation process and tactics. 2.1 Preparation, information gathering and strategy development. Effective negotiation begins with thorough preparation. This includes researching the other party, understanding legal and factual strengths, and planning opening moves. Real-life example, in merger negotiations, due diligence reveals financial and legal risks, informing negotiation strategy. A party with superior information can leverage it for better terms. Practical application, lawyers create negotiation plans with objectives, concessions, and fallback positions. Students practice preparation exercises with complex fact patterns. 2.2 Opening and bargaining, anchoring, framing, and concessions. The opening offer anchors the negotiation range. Framing influences perception, gains versus losses. Concessions should be reciprocal and strategic. Real-life example, in salary negotiations, the first number mentioned often sets the range. A candidate who anchors high may achieve a better outcome, provided the anchor is credible. Practical application, lawyers craft opening statements and manage concession patterns. Students practice anchoring and framing techniques in role plays. 2.3 Impasse and breakthrough, overcoming deadlocks. Negotiations often reach impasse. Techniques to overcome deadlocks include taking breaks, changing negotiators, introducing new options, or using mediators. Real-life example, in international diplomacy, third-party mediation, e.g., Camp David Accords, has broken deadlocks. In commercial disputes, mediators help parties see beyond positions. Practical application, lawyers recognize impasse signals and deploy breakthrough strategies. Students practice mediation skills and impasse resolution. 3. Specialized contexts, litigation, transactional, and cross-cultural negotiation. 3.1 Litigation negotiation, settlement conferences and plea bargaining. Most cases settle before trial. Settlement negotiations involve evaluating litigation risks, costs, and client preferences. Plea bargaining in criminal cases requires balancing charges, sentences, and defendant rights. Real-life example, in civil rights litigation, settlement conferences often involve structured negotiations with court oversight. Plea bargains resolve most criminal cases, but must be voluntary and intelligent. Practical application, lawyers prepare settlement proposals and advise clients on acceptance. Students practice settlement simulations and plea negotiations. 3.2 Transactional negotiation, contracts, mergers, and joint ventures. Transactional negotiations create agreements. Key issues include price, terms, representations, and dispute resolution. Relationship preservation is often important. Real-life example, in merger negotiations, parties negotiate valuation, governance, and post-closing obligations. Earnouts and escrows bridge valuation gaps. Practical application, lawyers draft term sheets and negotiate definitive agreements. Students practice contract negotiation exercises with multiple issues. 3.3 Cross-cultural negotiation, communication styles and norms. Cultural differences affect negotiation. Direct versus indirect communication, individual versus collective decision-making, and time perceptions vary. Real-life example, in some cultures, building relationships precedes business discussions. In others, efficiency is valued. Misunderstandings can derail deals. Practical application, lawyers research cultural norms and adapt styles. Students practice cross-cultural simulations with feedback. 4. Contemporary issues and professional preparation. 4.1 Technology and negotiation, virtual platforms and AI tools. Technology transforms negotiation. Video conferencing enables remote deals. AI tools analyze data and suggest terms. However, virtual negotiation lacks nonverbal cues. Real-life example, during the pandemic, many settlements were negotiated via Zoom. AI contract analysis tools help identify favorable terms. Practical application, lawyers master virtual negotiation platforms and evaluate AI tools. Students practice online negotiations and assess technology impacts. 4.2 Power dynamics and inequality in negotiation. Power imbalances, resources, information, status, affect outcomes. Ethical negotiators address inequality through process fairness and substantive safeguards. Real-life example, in consumer contracts, adhesion clauses favor drafters. Courts may invalidate unconscionable terms. Negotiators can empower weaker parties through transparency and options. Practical application, lawyers advocate for fair processes and terms. Students analyze power dynamics and practice empowerment techniques. 4.3 Learning outcomes and competency benchmarks. By completing negotiation skills, students should be able to prepare and execute negotiation strategies, apply distributive and integrative techniques, navigate ethical and cross-cultural challenges, achieve favorable outcomes in diverse contexts. Practical application, these outcomes are essential for all legal practice. Students should master negotiation as a core skill. 4.4 Assessment methods, simulations, reflection papers, and case analyses. Assessments include simulations, role-play negotiations with evaluation. Reflection papers, analyze personal negotiation style. Case analyses, evaluate negotiation strategies in real cases. Real-life example, a final project might involve negotiating a complex multi-party dispute. This mirrors high-stakes practice. Practical application, students should practice self-assessment and continuous improvement. 4.5 Transition to advanced courses, negotiation foundations for mediation and advocacy. Negotiation skills underpin dispute resolution. Advanced courses, mediation, advanced advocacy build on these concepts. Practice, negotiation is used in every legal context. Practical application, students should view negotiation as a lifelong skill. Mastery ensures client success. Slide 9. Year 3, Semester 2, Practical Legal Skills. Course, Law.310, Legal Drafting. Foundations of Legal Drafting, Clarity, Precision, and Purpose. 1.1 The Art and Science of Legal Drafting, Balancing Formality and Accessibility. Legal drafting is the craft of creating documents that clearly express legal rights, duties, and procedures. Effective drafting balances precision, avoiding ambiguity, with accessibility, ensuring understanding. Overly complex language can obscure meaning, oversimplification can create loopholes. Real-life example, in Raffles v. Whichelhouse, 1864, a contract for cotton, ex-Peerless from Bombay, was ambiguous because two ships named Peerless sailed from Bombay. The court held no contract existed due to mutual mistake. This illustrates how ambiguous drafting can defeat intent. Practical application, lawyers draft with the end user in mind, judges need clear legal arguments, clients need understandable advice, opposing counsel need unambiguous terms. Students practice rewriting convoluted clauses for clarity while preserving legal effect. 1.2 Audience analysis, judges, clients, legislators, and the public. Different audiences require different drafting approaches. Judicial briefs emphasize legal authority and logic. Client letters prioritize practical advice and plain language. Statutes must be precise for enforcement. Public documents need accessibility. Real-life example, a motion to dismiss cites controlling precedent and procedural rules. A client letter explaining the same motion translates legal jargon into actionable guidance. The same legal analysis is adapted for different readers. Practical application, lawyers identify the primary audience and tailor tone, structure, and terminology. Students practice drafting the same content for multiple audiences. They learn to avoid legalese when unnecessary. 1.3 Ethical obligations, candor, confidentiality, and competence. Drafting ethics require honesty, no misleading statements, confidentiality, protecting client information, and competence, adequate legal knowledge. Misleading drafts can constitute fraud, careless drafting can harm clients. Real-life example, in re Yagman, 1995, an attorney was sanctioned for filing frivolous motions with false statements. Similarly, drafting a contract with hidden unfavorable terms can lead to malpractice claims. Practical application, lawyers review drafts for accuracy and fairness. Students practice ethical screening of documents. They learn to balance advocacy with integrity. 2. Drafting fundamentals, structure, language, and style. 2.1 Organizational principles, headings, sequencing, and hierarchy. Well-organized documents guide readers through complex material. Headings break content into manageable sections. Logical sequencing, e.g., definitions first, then operative provisions, aids comprehension. Hierarchy, main provisions versus subparts, clarifies relationships. Real-life example, a well-drafted contract starts with recitals, background, then definitions, then substantive terms, then boilerplate. This structure helps parties locate provisions quickly. Practical application, lawyers use outlines before drafting. Students practice structuring documents with clear headings and logical flow. They learn to use tables of contents for long documents. 2.2 Plain language versus legal terminology, when to use each. Plain language improves accessibility, but legal terms of art have precise meanings. The key is using plain language where possible and legal terms where necessary. Real-life example, indemnify and hold harmless, is a term of art with specific legal effects. Replacing it with protect from loss may create ambiguity. However, force majeure can be explained as unforeseeable circumstances preventing performance. Practical application, lawyers define technical terms and use plain language elsewhere. Students practice translating legalese into plain English without losing legal precision. They learn to identify terms that must remain technical. 2.3 Avoiding ambiguity, syntax, punctuation, and definitions. Ambiguity arises from poor syntax, unclear punctuation, or undefined terms. Drafters use definitions sections, consistent terminology, and careful sentence structure to prevent misinterpretation. Real-life example, in Kirksey v. Kirksey, 1845, ambiguous language in a promise led to litigation over whether it was a gift or contract. Clear definitions and conditional language could have prevented the dispute. Practical application, lawyers use defined terms consistently and avoid pronouns with unclear antecedents. Students practice editing ambiguous clauses. They learn punctuation rules that affect meaning, e.g., Oxford comma. 3. Specialized drafting, contracts, pleadings, and legislation. 3.1 Contract drafting, terms, conditions, and remedies. Contracts allocate risks and define obligations. Key elements include parties, recitals, definitions, operative provisions, representations, covenants, conditions, remedies, and boilerplate. Real-life example, a well-drafted non-disclosure agreement defines confidential information, specifies permitted uses, sets duration, and outlines remedies for breach. Vague language can render it unenforceable. Practical application: lawyers draft contracts tailored to transaction specifics. Students practice drafting key clauses, e.g., indemnification, termination. They learn to anticipate and address potential disputes. 3.2 Pleading drafting: complaints, answers, and motions. Pleadings initiate and respond to litigation. They must state claims or defenses with sufficient factual specificity to provide notice and meet procedural standards. Real-life example: after Twombly/Iqbal, complaints must allege plausible claims, not just conclusory statements. A well-drafted complaint identifies elements, facts, and legal theories clearly. Practical application: lawyers draft pleadings that survive motions to dismiss. Students practice issue spotting and factual allegation. They learn to balance detail with brevity. 3.3 Legislative and regulatory drafting: statutes, rules, and policies. Legislative drafting creates laws, regulatory drafting implements them. Precision is critical because these documents govern broad populations. Real-life example: the Affordable Care Act's complex drafting led to numerous interpretive disputes. Clear statutory language reduces litigation and improves implementation. Practical application: lawyers draft legislation or comments on proposed rules. Students practice writing clear statutory provisions. They learn to consider enforcement and interpretation. 4. Contemporary issues and professional preparation. 4.1 Technology and drafting: templates, automation, and AI. Technology aids drafting through templates, document assembly, and AI tools. However, over-reliance can lead to errors if context is ignored. Real-life example: contract automation software generates standard agreements but requires lawyer review for customization. AI tools suggest clauses but cannot replace judgment. Practical application: lawyers use technology efficiently while maintaining oversight. Students practice using drafting tools and evaluating AI suggestions. They learn to balance efficiency with quality. 4.2 Globalization and cross-border drafting: harmonization and conflict. Cross-border transactions require drafting that accounts for multiple legal systems. Choice of law, jurisdiction, and enforcement clauses are critical. Real-life example: international contracts often include arbitration clauses to avoid national court biases. Drafting must comply with relevant conventions, e.g., New York Convention. Practical application: lawyers draft for enforceability in target jurisdictions. Students practice incorporating conflict of laws provisions. They learn to navigate harmonization efforts, e.g., UNCITRAL. 4.3 Learning outcomes and competency benchmarks. By completing legal drafting, students should be able to draft clear, precise, and effective legal documents. Adapt drafting style to audience and purpose. Avoid ambiguity and ethical pitfalls. Utilize technology and global considerations. Practical application: these outcomes are essential for all legal practice. Students should master drafting as a core competency. 4.4 Assessment methods: drafting exercises, peer review, and revision. Assessments include drafting exercises: create contracts, pleadings, or statutes. Peer review: critique classmates' drafts. Revision: improve drafts based on feedback. Real-life example: a final project might involve drafting a complete contract for a complex transaction. This mirrors real-world practice. Practical application: students should practice iterative drafting and feedback incorporation. 4.5 Transition to advanced courses: drafting foundations for specialized practice. Legal drafting underpins advanced work. Advanced courses, transactional law, advanced litigation build on these skills. Practice: drafting is used in every legal task. Practical application: students should view drafting as a fundamental skill. Mastery ensures professional effectiveness. Slide 9. Year 3, Semester 2, Practical Legal Skills. Course: Law.311, Law of Evidence. I. Advanced Evidence Doctrines, Hearsay, Privileges, and Expert Testimony. 1.1 Hearsay Exceptions and Constitutional Limitations. Hearsay rules exclude out-of-court statements offered for truth, but numerous exceptions exist based on reliability. The Confrontation Clause further limits hearsay in criminal cases. Real-life example, in Crawford v. Washington, 2004, the Supreme Court held that testimonial hearsay violates the Sixth Amendment unless the declarant is unavailable and the defendant had prior cross-examination opportunity. This transformed criminal evidence practice. Practical application: lawyers must distinguish testimonial from non-testimonial hearsay and lay proper foundations for exceptions. Students practice analyzing confrontation issues and hearsay exceptions in criminal and civil contexts. 1.2 Privileges, Scope, Waiver, and Ethical Tensions. Privileges protect confidential communications, attorney-client, spousal, doctor-patient. Scope varies by jurisdiction. Waiver can occur through disclosure. Ethical tensions arise when privilege conflicts with truth-seeking. Real-life example, in Upjohn Company v. United States, 1981, the Supreme Court expanded attorney-client privilege to corporate employees communicating with counsel for legal advice. This protects corporate compliance but can conceal wrongdoing. Practical application: lawyers assert privileges strategically and advise clients on waiver risks. Students analyze privilege logs and waiver scenarios. They learn to balance confidentiality with disclosure obligations. 1.3 Expert Testimony, Daubert, Reliability, and Jury Impact. Expert testimony assists fact-finders with specialized knowledge. The Daubert standard requires reliability and relevance. Judges act as gatekeepers to exclude junk science. Real-life example, in Daubert v. Merrill Dow Pharmaceuticals, 1993, the court established factors for scientific validity, testing, peer review, error rates, and acceptance. This prevents unreliable expert opinions from misleading juries. Practical application: lawyers qualify experts and challenge methodologies. Students practice Daubert hearings and expert examinations. They learn to present complex science clearly. 2. Evidence in practice, trial strategy and appellate review. 2.1 Trial strategy, offers of proof, objections, and jury instructions. Effective evidence use requires strategic planning. Offers of proof preserve issues for appeal. Timely objections prevent prejudicial evidence. Jury instructions frame evidence evaluation. Real-life example, in Old Chief v. United States, 1997, the defense's offer to stipulate to a prior conviction was accepted to prevent prejudice. Strategic evidence decisions can shape trial outcomes. Practical application: lawyers plan evidence presentation and objection strategies. Students practice making offers of proof and drafting jury instructions. They learn to anticipate appellate issues. 2.2 Appellate review, standards of review and preservation of error. Appellate courts review evidentiary rulings for abuse of discretion. Errors must be preserved through objections. Harmless error doctrine limits reversal to prejudicial mistakes. Real-life example, in United States v. Abel, 1984, the court reviewed bias evidence admission under abuse of discretion, affirming the trial court's balance of probative value and prejudice. Practical application: lawyers preserve errors and frame appellate arguments. Students practice identifying reversible error and drafting appellate briefs on evidence issues. 2.3 Digital evidence, authentication, hearsay, and privacy. Digital evidence, emails, social media, metadata, poses authentication and hearsay challenges. Privacy laws affect admissibility. Real-life example, in United States v. Vayner, 2014, a Facebook profile was authenticated through witness testimony. Courts adapt traditional evidence rules to digital contexts. Practical application: lawyers authenticate digital evidence and navigate privacy statutes. Students practice digital evidence foundations and hearsay analysis. 3. contemporary issues and professional preparation. 3.1 Scientific evidence and emerging technologies. New technologies, DNA, neuroscience, challenge evidence law. Reliability standards must evolve. Real-life example, DNA evidence revolutionized criminal trials but requires careful handling to avoid contamination. AI-generated evidence raises authenticity questions. Practical application, lawyers stay current on scientific developments and evidence standards. Students analyze emerging technology admissibility. 3.2 Trauma-informed evidence, victim testimony and credibility. Trauma affects memory and testimony. Courts increasingly recognize trauma-informed approaches to evidence evaluation. Real-life example, in sexual assault cases, delayed reporting or inconsistent statements may reflect trauma rather than fabrication. Expert testimony on trauma can aid jury understanding. Practical application, lawyers present trauma-informed evidence and challenge stereotypes. Students practice sensitive examination techniques. 3.3 Learning outcomes and competency benchmarks. By completing law of evidence, students should be able to apply advanced hearsay, privilege, and expert testimony doctrines. Develop trial and appellate evidence strategies. Navigate digital and scientific evidence challenges. Incorporate trauma-informed practices. Practical application, these outcomes are essential for litigation practice. Students should master evidence as a tactical tool. 3.4 Assessment methods, trial simulations, appellate briefs, and evidence motions. Assessments include trial simulations, conduct examinations with evidentiary objections. Appellate briefs, argue evidence issues on appeal. Evidence motions, draft motions in limine and Daubert challenges. Real-life example, a final project might involve a full trial simulation with evidentiary rulings. This mirrors litigation practice. Practical application, students should practice real-time evidence decision-making. 3.5 Transition to advanced courses, evidence foundations for complex litigation and criminal practice. Evidence law underpins advanced advocacy. Advanced courses, complex litigation, criminal trial practice build on these concepts. Practice, evidence determines case outcomes. Practical application, students should view evidence as a strategic advantage. Mastery ensures trial success. Slide 9. Year 3, Semester 2, Practical Legal Skills. Course, Law. 312, Consumer Protection Law. Foundations of Consumer Protection, Statutes, Regulations, and Enforcement. 1.1 Federal and State Consumer Protection Frameworks. Consumer protection law combines federal statutes, e.g., FTC Act, Truth in Lending Act, and state laws, e.g., Unfair and Deceptive Acts and Practices statutes. The Federal Trade Commission, FTC, enforces federal law, state attorneys general and private plaintiffs enforce state law. Real-life example, the FTC's action against Volkswagen for clean diesel emissions fraud resulted in billions in settlements. State AGs joined the litigation, illustrating cooperative enforcement. Practical application, lawyers advise businesses on compliance and represent consumers in enforcement actions. Students analyze statutory elements and enforcement mechanisms. 1.2 Unfair and deceptive practices, definitions and applications. The core prohibition is against unfair or deceptive acts or practices. Deceptive involves material misrepresentations likely to mislead reasonable consumers. Unfair involves substantial injury not outweighed by benefits. Real-life example, in FTC v. Wyndham Worldwide Corporation, 2015, the Third Circuit upheld FTC authority to regulate data security as an unfair practice. This expanded consumer protection to cybersecurity. Practical application, lawyers evaluate marketing claims and business practices for compliance. Students practice applying deception and unfairness tests to fact patterns. 1.3 Private rights of action and class actions. Many consumer protection statutes allow private suits, often as class actions. Requirements include numerosity, commonality, typicality, and adequacy. Real-life example, in Spokio Incorporated v. Robbins, 2016, the Supreme Court clarified standing requirements for statutory damages, affecting class certification in consumer cases. Practical application, lawyers draft class complaints and defend against certification. Students analyze class action prerequisites and standing issues. 2. Substantive areas, advertising, privacy, and financial protection. 2.1 Advertising and marketing, truthfulness, substantiation, and endorsements. Advertising law requires truthfulness, substantiation of claims, and disclosure of material connections. Endorsements must reflect honest opinions. Real-life example, the FTC's endorsement guides require influencers to disclose paid partnerships. Failure to do so can result in enforcement actions. Practical application, lawyers review advertising campaigns for compliance. Students practice drafting disclosure language and evaluating substantiation. 2.2 Privacy and data protection, consumer rights and business obligations. Privacy laws protect consumer data. The FTC enforces against unfair privacy practices. State laws, e.g., CCPA, grant consumer rights to access, delete, and opt out of data sales. Real-life example, in FTC v. Facebook, 2019, the FTC imposed a $5 billion penalty for privacy violations, illustrating enforcement severity. Practical application, lawyers advise on privacy policies and data practices. Students analyze compliance with federal and state privacy laws. 2.3 Financial services, lending, credit reporting, and debt collection. Consumer financial protection is governed by statutes like Truth in Lending Act, TILA, Fair Credit Reporting Act, FCRA, and Fair Debt Collection Practices Act, FDCPA. Real-life example, in TransUnion LLC v. Ramirez, 2021, the Supreme Court limited standing for FCRA claims without concrete harm, affecting consumer litigation. Practical application, lawyers handle credit reporting disputes and debt collection defense. Students practice applying financial protection statutes. 3. Enforcement and remedies, administrative, civil, and criminal. 3.1 Administrative enforcement, FTC and agency actions. The FTC uses administrative proceedings and federal court actions to enforce consumer protection law. Remedies include injunctions, restitution, and civil penalties. Real-life example, FTC consent orders often require comprehensive compliance programs and monitoring. Practical application, lawyers represent clients in FTC investigations and negotiate settlements. Students practice responding to civil investigative demands. 3.2 Civil litigation, individual and class actions. Private plaintiffs can sue for damages, injunctions, and statutory penalties. Class actions aggregate small claims. Real-life example, in Tyson Foods Incorporated v. Buafacchio, 2016, the Supreme Court allowed class certification based on representative evidence, facilitating consumer class actions. Practical application, lawyers litigate consumer claims and defend businesses. Students practice drafting complaints and motions to dismiss. 3.3 Criminal enforcement, fraud and penalties. Some consumer violations rise to criminal fraud, e.g., wire fraud, mail fraud. Prosecutors pursue criminal cases for egregious conduct. Real-life example, the prosecution of Theranos executives for fraud illustrates criminal enforcement in consumer protection. Practical application, lawyers defend against criminal charges or prosecute violations. Students analyze criminal elements in consumer fraud. 4. Contemporary issues and professional preparation. 4.1 Digital commerce and emerging platforms. E-commerce, apps, and platforms create new consumer protection challenges. Jurisdictional issues, terms of service enforcement, and algorithmic discrimination are evolving areas. Real-life example, The FTC's actions against dark patterns, deceptive design, in digital interfaces show adaptation to new technologies. Practical application, lawyers advise digital businesses on compliance. Students analyze platform liability and consumer rights online. 4.2 Global consumer protection, cross-border enforcement. Global commerce requires cross-border enforcement cooperation. International networks, e.g., ICBAN, facilitate collaboration. Real-life example, the FTC's cooperation with foreign agencies in combating international scams illustrates global enforcement. Practical application, lawyers navigate international consumer protection laws. Students study cross-border enforcement mechanisms. 4.3 Learning outcomes and competency benchmarks. By completing consumer protection law, students should be able to navigate federal and state consumer protection frameworks, analyze unfair/deceptive practices and advertising claims, handle privacy, financial, and digital commerce issues, pursue or defend enforcement actions. Practical application, these outcomes are essential for consumer advocacy and business compliance. Students should master consumer protection statutes. 4.4 Assessment methods, case studies, compliance audits, and drafting. Assessments include: case studies, analyze enforcement actions. Compliance audits, evaluate business practices. Drafting, write consumer complaints or compliance policies. Real-life example, a final project might involve drafting a class action complaint for a data breach. This mirrors consumer litigation. Practical application, students should practice enforcement strategy and compliance counseling. 4.5 Transition to advanced courses, consumer protection foundations for privacy and commercial law. Consumer protection law underpins related fields. Advanced courses, privacy law, commercial litigation build on these concepts. Practice, consumer protection intersects with many practice areas. Practical application, students should view consumer protection as a dynamic field. Mastery ensures effective advocacy. Slide 9. Year 3, Semester 2, Practical Legal Skills. Course, Law.313, Criminal Justice System. Structure and function of the criminal justice system, police, courts, and corrections. 1.1 Institutional roles and interactions. The criminal justice system comprises law enforcement, courts, and corrections. Each institution has distinct functions but must coordinate for effective justice. Real-life example, police investigate crimes, prosecutors charge, courts adjudicate, and corrections administer sentences. Breakdowns in coordination, e.g., evidence mishandling, can lead to wrongful convictions. Practical application, lawyers navigate interactions among institutions. Students analyze institutional roles and interdependencies. 1.2 Discretion and accountability, prosecutorial, judicial, and administrative discretion. Discretion is inherent at each stage. Police decide whom to arrest, prosecutors decide whom to charge, judges decide sentences, and parole boards decide release. Accountability mechanisms, oversight, appeals, review, check discretion. Real-life example, prosecutorial discretion in plea bargaining resolves most cases but raises fairness concerns. Judicial sentencing guidelines limit but do not eliminate discretion. Practical application, lawyers exercise and challenge discretion. Students analyze discretion's impact on outcomes and equity. 1.3 Systemic issues, racial disparities, mass incarceration, and reform. The system exhibits racial and economic disparities. Mass incarceration results from tough on-crime policies. Reform efforts address sentencing, bail, and re-entry. Real-life example, the First Step Act, 2018, reduced federal sentences and improved prison conditions. State reforms address cash bail and mandatory minimums. Practical application, lawyers advocate for systemic reform. Students analyze disparity data and reform proposals. 2. Criminal Procedure in Practice, Investigation to Reentry. 2.1 Investigation and Charging, Police Practices and Prosecutorial Screening. Investigation involves evidence collection, witness interviews, and forensic analysis. Prosecutors screen cases for legal sufficiency and policy priorities. Real-life example, body-worn cameras increase transparency but raise privacy concerns. Prosecutors use declination policies to avoid overcharging. Practical application, lawyers advise on investigation legality and charging decisions. Students practice case screening and evidence evaluation. 2.2 Adjudication, plea bargaining, trial, and sentencing. Most cases resolve through plea bargaining. Trials involve jury selection, evidence presentation, and verdict. Sentencing considers guidelines, discretion, and individual circumstances. Real-life example, plea bargaining efficiency comes at the cost of trial rights. Sentencing reforms aim to reduce disparities. Practical application, lawyers negotiate pleas, conduct trials, and advocate at sentencing. Students practice plea negotiations and sentencing advocacy. 2.3 Corrections and Reentry, Incarceration, Parole, and Rehabilitation. Corrections administer sentences. Parole and probation supervise release. Reentry programs address recidivism. Real-life example, risk assessment tools guide parole decisions but may embed bias. Reentry programs reduce recidivism through employment and housing support. Practical application, lawyers represent clients in parole hearings and reentry planning. Students analyze correctional policies and rehabilitation effectiveness. 3. Contemporary issues and professional preparation. 3.1 Technology and criminal justice, surveillance, forensics, and data. Technology transforms criminal justice, surveillance tools, forensic science, and data analytics. These raise privacy, accuracy, and bias concerns. Real-life example, DNA exonerations reveal wrongful convictions but also raise privacy issues with genetic databases. Predictive policing algorithms may perpetuate bias. Practical application, lawyers navigate technology's legal and ethical implications. Students analyze forensic reliability and algorithmic fairness. 3.2 Mental health in criminal justice, diversion, treatment, and competency. Mental health issues are prevalent in the system. Diversion programs offer treatment instead of punishment. Competency evaluations ensure fair proceedings. Real-life example, mental health courts address underlying issues. Competency restoration programs prepare defendants for trial. Practical application, lawyers advocate for diversion and competency. Students practice mental health law applications. 3.3 Learning outcomes and competency benchmarks. By completing criminal justice system, students should be able to navigate institutional roles and discretion. Analyze procedure from investigation to reentry. Address systemic issues and reform efforts. Incorporate technology and mental health considerations. Practical application, these outcomes are essential for criminal practice and policy. Students should master criminal justice dynamics. 3.4 Assessment methods, case studies, policy analysis, and simulations. Assessments include case studies, analyze systemic issues. Policy analysis, evaluate reform proposals. Simulations, practice plea negotiations or sentencing hearings. Real-life example, a final project might involve designing a reentry program. This mirrors policy work. Practical application, students should practice systemic thinking and advocacy. 3.5 Transition to advanced courses, criminal justice foundations for specialized practice. Criminal justice system underpins advanced criminal law. Advanced courses, white-collar crime, capital punishment build on these concepts. Practice, understanding the system is vital for all criminal practice. Practical application, students should view the system holistically. Mastery ensures effective representation. Slide 9. Year 3, Semester 2, Practical Legal Skills. Course, Law.314, Forensic Law. Foundations of Forensic Law, Science, Law, and Interdisciplinary Practice. 1.1 The intersection of law and forensic science. Forensic law applies scientific methods to legal questions. It encompasses forensic disciplines, DNA, fingerprints, ballistics, digital forensics, and their legal admissibility. Understanding both scientific validity and legal standards is essential. Real-life example, in Daubert v. Merrill Dow Pharmaceuticals, 1993, the Supreme Court established reliability standards for expert testimony, directly impacting forensic science admissibility. This requires lawyers to understand scientific methodology. Practical application, lawyers evaluate forensic evidence for reliability and relevance. Students practice applying Daubert factors to forensic disciplines. They learn to cross-examine expert witnesses effectively. 1.2 Forensic disciplines, methods, limitations, and error rates. Each forensic discipline has specific methods, validation requirements, and known error rates. DNA analysis is highly reliable, bite mark analysis has been discredited. Real-life example, the National Academy of Sciences 2009 report highlighted limitations in many forensic disciplines, prompting reforms. Courts now scrutinize forensic testimony more carefully. Practical application, lawyers stay current on forensic science developments. Students analyze validation studies and error rate data. They learn to challenge unreliable forensic evidence. 1.3 Ethical obligations, objectivity, disclosure, and misconduct. Forensic experts must maintain objectivity and disclose limitations. Prosecutors have a duty to disclose exculpatory forensic evidence. Misconduct, e.g., fabricated results, undermines justice. Real-life example, the FBI's review of microscopic hair comparison testimony revealed widespread overstatement of matches, leading to case reviews and exonerations. Practical application, lawyers ensure forensic evidence is ethically obtained and presented. Students practice ethical analysis of forensic practices. They learn to identify and challenge misconduct. 2. Forensic evidence in criminal and civil litigation. 2.1 Criminal cases, DNA, fingerprints, and digital forensics. Forensic evidence is crucial in criminal cases. DNA can exonerate or convict. Fingerprints require careful analysis. Digital forensics extracts evidence from electronic devices. Real-life example, the Innocence Project uses DNA testing to exonerate wrongfully convicted individuals, illustrating forensic science's power and limitations. Practical application, lawyers handle forensic evidence in criminal trials. Students practice DNA chain of custody and digital evidence authentication. They learn to present complex science to juries. 2.2 Civil cases, toxic torts, product liability, and accident reconstruction. Forensic evidence also applies in civil litigation. Toxic torts require epidemiological and exposure analysis. Product liability involves engineering forensics. Accident reconstruction uses physics and engineering. Real-life example, in asbestos litigation, forensic pathology and industrial hygiene evidence establish causation. Product defect cases rely on failure analysis. Practical application, lawyers use forensic evidence to prove civil claims. Students practice causation analysis and expert qualification. They learn to integrate scientific and legal arguments. 2.3 Admissibility and challenge, Daubert, Frye, and procedural rules. Forensic evidence must meet admissibility standards. Federal courts use Daubert, some states use Frye, general acceptance. Procedural rules govern discovery and disclosure. Real-life example, in United States v. Green, 2005, the court excluded firearm toolmark testimony as insufficiently reliable under Daubert. This illustrates judicial gatekeeping. Practical application, lawyers file motions to admit or exclude forensic evidence. Students practice Daubert hearings and procedural compliance. They learn to navigate differing standards. 3. Contemporary issues and professional preparation. 3.1 Emerging forensic technologies, AI, biometrics, and genetic genealogy. New technologies expand forensic capabilities but raise legal and ethical questions. AI analyzes patterns, biometrics identify individuals, genetic genealogy solves cold cases. Real-life example, the Golden State Killer case used genetic genealogy to identify a suspect, raising privacy concerns about familial DNA searching. Practical application, lawyers advise on the use of emerging forensic technologies. Students analyze privacy and reliability issues. They learn to balance innovation with rights protection. 3.2 Wrongful convictions and forensic reform, lessons and improvements. Forensic errors contribute to wrongful convictions. Reforms include accreditation, proficiency testing, and transparency. Real-life example, the establishment of forensic science commissions in some states aims to improve standards and oversight. Practical application, lawyers advocate for forensic reform and represent exonerees. Students study wrongful conviction cases and reform proposals. They learn to promote best practices. 3.3 Learning outcomes and competency benchmarks. By completing forensic law, students should be able to evaluate forensic evidence for reliability and admissibility. Apply forensic science in criminal and civil litigation. Navigate ethical and procedural requirements. Address emerging technologies and reform efforts. Practical application, these outcomes are essential for litigation practice involving scientific evidence. Students should master forensic law fundamentals. 3.4 Assessment methods, case analyses, motions, and expert examinations. Assessments include case analyses, evaluate forensic evidence in real cases. Motions, draft Daubert motions and discovery requests. Expert examinations, practice direct and cross-examination of forensic experts. Real-life example, a final project might involve challenging forensic evidence in a mock trial. This mirrors litigation practice. Practical application, students should practice scientific literacy and legal advocacy. 3.5 Transition to advanced courses, forensic law foundations for complex litigation and criminal practice. Forensic law underpins advanced evidence and criminal practice. Advanced courses, advanced evidence, criminal trial practice build on these concepts. Practice, forensic evidence is increasingly central to litigation. Practical application, students should view forensic law as a critical competency. Mastery ensures effective use of scientific evidence. Slide 10. Year 4, Semester 1, Advanced Legal Practice. Course, Law.401, Ethics in Law Practice. Foundations of Professional Ethics, Rules, Values, and Professional Identity. 1.1 The Regulatory Framework, Model Rules, State Variations, and Disciplinary Systems. Legal ethics is governed by a complex regulatory framework that balances professional autonomy with public protection. The American Bar Association's Model Rules of Professional Conduct serve as the template for most U.S. jurisdictions, though states adopt variations reflecting local values and practices. Understanding this framework is essential for navigating ethical dilemmas and avoiding disciplinary sanctions. Real-life example, in re-disciplinary proceeding against Smith, hypothetical, a lawyer who commingled client funds with personal accounts faced disbarment under Rule 1.15, Safekeeping Property. This illustrates the strict liability nature of certain ethical rules. Intent is irrelevant, the violation itself triggers sanctions. Conversely, in re complex litigation ethics, hypothetical, a lawyer's good faith but erroneous interpretation of a conflict rule might result in a private admonition rather than public discipline, showing how intent and harm affect outcomes. Practical application, lawyers must maintain current knowledge of applicable rules in every jurisdiction where they practice. This requires ongoing CLE, subscription to ethics updates, and consultation with ethics counsel when uncertain. Students practice analyzing fact patterns under multiple state rules to identify variations. They learn to draft engagement letters that comply with jurisdiction-specific disclosure requirements. 1.2 Core Ethical Principles: Competence, Diligence, Communication, and Confidentiality. 4 principles anchor professional ethics: competence, Rule 1.1, diligence, Rule 1.3, communication, Rule 1.4, and confidentiality, Rule 1.6. These are not mere technical requirements but foundational to the lawyer-client relationship and the administration of justice. Competence requires legal knowledge, skill, thoroughness, and preparation. Comment 8 to Rule 1.1 now includes technological competence. Lawyers must understand relevant technology risks and benefits. Diligence requires acting with commitment and promptness. This includes managing workload to avoid neglect and meeting deadlines. Communication requires keeping clients reasonably informed, explaining matters to permit informed decisions, and responding to inquiries. Confidentiality protects all information relating to representation, with narrow exceptions, e.g., preventing death or substantial bodily harm. Real-life example: in Strickland v. Washington, 1984, the Supreme Court's ineffective assistance of counsel standard reflects the competence and diligence duties. A lawyer who fails to investigate mitigating evidence in a capital case may provide constitutionally deficient representation. Similarly, in Re Ryder, 1968, a lawyer's failure to communicate settlement offers led to discipline, illustrating the communication duty's practical importance. Practical application: lawyers implement systems to ensure competence, continuing education, mentorship, diligence, docketing, delegation, communication, regular updates, plain language explanations, and confidentiality, secure communications, staff training. Students practice drafting client communication protocols and analyzing confidentiality scenarios. They learn to balance zealous advocacy with ethical constraints. 1.3 Professional identity formation: values, virtues, and the lawyer's role. Beyond rule compliance, ethical practice requires developing a professional identity grounded in values and virtues. This includes integrity, courage, empathy, and commitment to justice. The lawyer's role involves tensions: advocate versus officer of the court, zealous representative versus truth seeker, businessperson versus fiduciary. Real-life example: in Nix v. Whiteside, 1986, the Supreme Court held that a lawyer's duty of candor to the tribunal overrides a client's desire to commit perjury. This illustrates the lawyer's dual role, advocating for the client while upholding the integrity of the judicial process. Lawyers who internalize this balance navigate ethical dilemmas more effectively. Practical application: lawyers reflect on their professional identity through mentorship, journaling, and ethics discussions. Students engage in values-based case studies, exploring how personal convictions interact with professional obligations. They practice articulating ethical reasoning in writing and oral argument. 2. Conflicts of interest: loyalty, independence, and informed consent. 2.1 Current client conflicts: direct adversity and material limitation. Rule 1.7 prohibits representation of a client if it involves direct adversity to another current client or if there is a significant risk that representation will be materially limited by the lawyer's responsibilities to another client, a third party, or the lawyer's own interests. Direct adversity: representing one party against another current client in the same or a substantially related matter. Material limitation: even without direct adversity, conflicts arise if the lawyer's judgment could be compromised, e.g., representing multiple parties in a transaction with potentially divergent interests. Informed consent: conflicts may be waived if the lawyer reasonably believes competent representation is possible, the representation is not prohibited by law, and each affected client gives informed consent confirmed in writing. Real-life example: in Fiandica v. Cunningham, 1988, a law firm representing both a teachers' union and individual teachers in a school desegregation case was disqualified because settlement opportunities for one group conflicted with the other's interests. This illustrates how even well-intentioned dual representation can create irreconcilable conflicts. Practical application: lawyers conduct conflict checks before accepting new matters and when circumstances change. They document informed consent discussions, ensuring clients understand risks and alternatives. Students practice analyzing complex conflict scenarios and drafting consent forms. They learn to recognize when conflicts are non-consentable, e.g., representing both sides in litigation. 2.2 Former client conflicts, substantial relationship and confidential information. Rule 1.9 prohibits representation adverse to a former client in the same or a substantially related matter if the new client's interests are materially adverse to the former client's, unless the former client gives informed consent. Substantial relationship test: matters are substantially related if they involve the same transaction or legal dispute, or if there is a substantial risk that confidential information from the prior representation would advance the new client's position. Confidential information: even without a substantial relationship, lawyers cannot use former client confidences to the former client's disadvantage. Real-life example: in Trone v. Smith, 1980, a lawyer who previously represented a company in labor negotiations was disqualified from representing employees against the company in a related wage dispute. The court found a substantial relationship because the prior representation involved similar legal issues and confidential business information. Practical application: lawyers screen lateral hires for former client conflicts and implement ethical walls when necessary. Students practice applying the substantial relationship test to fact patterns. They learn to draft screening protocols and consent waivers. 2.3 Imputation and screening, firm-wide conflicts and ethical walls. Under Rule 1.10, conflicts are generally imputed to all lawyers in a firm. However, screening may prevent imputation in certain circumstances, e.g., when a lateral lawyer joins a firm with a conflict from prior employment. Screening requirements: the disqualified lawyer must be screened from participation in the matter, receive no fee from it, and written notice must be given to affected clients. Limitations: screening is not permitted for all conflicts, e.g., it generally cannot cure a current client conflict under Rule 1.7. Real-life example: in Cassis v. Teachers, Insurance and Annuity Association, 1999, a court allowed screening to prevent imputation when a lateral lawyer brought a conflict from prior employment, provided robust screening measures were implemented. This illustrates the conditions under which screening is effective. Practical application: lawyers design and implement ethical walls, documenting screening procedures and monitoring compliance. Students practice drafting screening protocols and analyzing their sufficiency. They learn to advise firms on lateral hire due diligence. 3. Advocacy ethics, candor, fairness, and tribunal relations. 3.1 Candor to the tribunal, truthfulness, disclosure, and correcting falsehoods. Rule 3.3 requires lawyers to be candid with tribunals. This includes not making false statements of law or fact, disclosing adverse legal authority, and correcting prior false statements. False statements: lawyers cannot knowingly make false factual or legal assertions. This extends to failing to correct a client's false testimony. Adverse authority: lawyers must disclose controlling legal authority in the jurisdiction that is directly adverse to their position and not disclosed by opposing counsel. Correcting falsehoods: if a lawyer later learns that evidence they offered is false, they must take reasonable remedial measures, including disclosure if necessary. Real-life example: in re Yagman, 1995, an attorney was sanctioned for filing frivolous motions containing false statements about judicial conduct. This illustrates the consequences of violating candor duties. Conversely, in Nix v. Whiteside, 1986, the court affirmed that lawyers must prevent or correct client perjury, even over client objections. Practical application: lawyers verify factual assertions before filing and research legal authority thoroughly. Students practice identifying adverse authority and drafting disclosure statements. They learn to navigate client pressure to withhold unfavorable information. 3.2 Fairness to opposing party and counsel, discovery, communications, and tactics. Rule 3.4 governs fairness in dealings with opponents. Lawyers cannot unlawfully obstruct access to evidence, falsify evidence, or make frivolous discovery requests. They must respect third-party rights and avoid improper ex parte communications. Discovery abuse: lawyers cannot suppress evidence, make improper objections, or fail to comply with discovery obligations. Ex parte communications: lawyers generally cannot communicate with represented persons without consent of their counsel, Rule 4.2, or with judges about pending matters without notice to opponents. Real-life example: in re complex litigation, hypothetical, a lawyer who secretly contacted a represented witness faced sanctions under Rule 4.2. This illustrates the strict prohibition on bypassing opposing counsel. Similarly, discovery sanctions under Rule 37 deter abusive tactics. Practical application: lawyers train staff on discovery protocols and communication rules. Students practice drafting proper discovery requests and responding to objections. They learn to document communications to avoid ex parte violations. 3.3 Special responsibilities of prosecutors and government lawyers. Rule 3.8 imposes additional duties on prosecutors, including refraining from prosecuting without probable cause, making timely disclosure of exculpatory evidence, and avoiding improper subpoena use. Brady obligations: prosecutors must disclose evidence favorable to the accused, including impeachment material. Improper tactics: prosecutors cannot use media to prejudice proceedings or pressure defendants into waiving rights. Real-life example: in Connick v. Thompson, 2011, the Supreme Court limited civil liability for Brady violations but affirmed prosecutors' ethical duty to disclose exculpatory evidence. This illustrates the tension between ethical obligations and legal accountability. Practical application: prosecutors implement disclosure protocols and train staff on ethical obligations. Students practice analyzing Brady scenarios and drafting disclosure policies. They learn to balance zealous prosecution with fairness duties. 4. Contemporary issues and professional preparation. 4.1 Technology and ethics, confidentiality, competence, and social media. Technology creates new ethical challenges. Lawyers must protect client data in digital communications, understand e-discovery obligations, and avoid improper social media conduct. Confidentiality: Rule 1.6 requires reasonable efforts to prevent unauthorized access to client information. This includes encryption, secure cloud storage, and staff training. Competence: Comment 8 to Rule 1.1 requires understanding technology relevant to practice. Lawyers must stay current on cybersecurity threats and digital tools. Social media: lawyers cannot communicate with jurors online, must avoid misleading online profiles, and should consider the ethical implications of online marketing. Real-life example: in re Anonymous, 2013, a lawyer was disciplined for failing to secure client data on a stolen laptop, illustrating confidentiality obligations in the digital age. Similarly, courts have sanctioned lawyers for improper social media contact with jurors. Practical application: lawyers implement technology policies, conduct cybersecurity audits, and train staff on digital ethics. Students practice drafting technology usage agreements and analyzing social media scenarios. They learn to balance innovation with risk management. 4.2 Diversity, equity, and inclusion, ethical obligations and professional culture. Ethical practice includes fostering a diverse, equitable, and inclusive profession. Rule 8.4 G in some jurisdictions prohibits harassment and discrimination in practice. Beyond rules, lawyers have a professional responsibility to promote access to justice and challenge systemic bias. Rule 8.4 G prohibits conduct that a lawyer knows or reasonably should know is harassment or discrimination based on protected characteristics. Access to justice: lawyers should provide pro bono service and support legal aid organizations. Inclusive practice: lawyers should create welcoming environments for diverse clients and colleagues. Real-life example: in jurisdictions adopting Rule 8.4 G, lawyers have faced discipline for discriminatory conduct in practice. This illustrates the evolving scope of ethical obligations. Pro bono programs demonstrate the profession's commitment to access. Practical application: lawyers adopt inclusive hiring and client service practices, track pro bono hours, and participate in diversity initiatives. Students practice analyzing discrimination scenarios and drafting inclusion policies. They learn to integrate equity considerations into ethical decision-making. 4.3 Learning outcomes and competency benchmarks. By completing ethics and law practice, students should be able to navigate the regulatory framework of professional ethics, identify and resolve conflicts of interest, uphold advocacy ethics in tribunal and opposing party dealings, address contemporary challenges, technology, diversity. Practical application: these outcomes are essential for all legal practice. Students should master ethical reasoning and rule application. 4.4 Assessment methods: case studies, ethics opinions, and simulations. Assessments include case studies, analyze disciplinary decisions and ethical dilemmas. Ethics opinions, draft advisory opinions on hypothetical scenarios. Simulations, role-play ethical decision-making in practice contexts. Real-life example: a final project might involve advising a law firm on implementing a new technology platform while ensuring confidentiality compliance. This mirrors real-world ethics counseling. Practical application: students should practice ethical analysis and communication. 4.5 Transition to advanced courses, ethics foundations for specialized practice. Ethics in law practice underpins all advanced legal work. Advanced courses, clinical programs, advanced advocacy build on these concepts. Practice: ethical competence is a lifelong requirement. Practical application: students should view ethics as integral to professional excellence. Mastery ensures trust and effectiveness. Slide 10. Year 4, Semester 1, Advanced Legal Practice. Course, Law. 402, Advanced Legal Practice. Foundations of Advanced Practice, Integration, Specialization, and Professional Development. 1.1 From Doctrine to Practice, Integrating Knowledge Across Substantive Areas. Advanced legal practice requires synthesizing knowledge from multiple substantive fields. Real-world problems rarely fit neatly into one doctrinal category. They involve intersecting issues of contract, tort, procedure, ethics, and policy. Lawyers must identify relevant legal frameworks, prioritize issues, and develop coherent strategies. Real-life example: a complex commercial dispute might involve contract interpretation, substantive law, discovery disputes, procedure, potential sanctions, ethics, and settlement negotiations. Practice skills. A lawyer who understands only contract doctrine will miss procedural opportunities and ethical constraints. Integration enables comprehensive representation. Practical application: lawyers use issue-spotting checklists and interdisciplinary teams to address complex matters. Students practice analyzing multi-issue fact patterns, identifying doctrinal intersections, and developing integrated strategies. They learn to prioritize issues based on client goals and legal leverage. 1.2 Specialization and generalism, depth, breadth, and career strategy. The legal profession offers paths of specialization, deep expertise in a niche, and generalism, broad competence across areas. Both have value. Specialists command premium rates and handle complex matters. Generalists serve diverse client needs and adapt to changing markets. Specialization requires focused CLE, certification, where available, and reputation building. Examples: intellectual property, tax, environmental law. Generalism requires continuous learning across domains, strong research skills, and referral networks. Examples: small firm practice, in-house counsel. Real-life example: a lawyer specializing in data privacy may command higher fees and handle GDPR compliance for multinational clients. A generalist in a rural community may handle family law, real estate, and criminal defense, building deep client relationships. Both paths can be successful with intentional development. Practical application: lawyers assess their interests, market demands, and lifestyle preferences to choose a path. Students practice career planning, identifying specialization opportunities and generalist skill building. They learn to market their expertise effectively. 1.3 Professional development, mentorship, networking, and lifelong learning. Legal practice evolves rapidly, lawyers must commit to lifelong learning. Mentorship accelerates skill development, networking creates opportunities, CLE maintains competence. Mentorship: formal programs pair junior and senior lawyers for guidance on practice skills, ethics, and career navigation. Networking: bar associations, alumni groups, and industry events build relationships that lead to referrals, collaborations, and insights. Lifelong learning: beyond CLE requirements, lawyers read scholarship, attend conferences, and reflect on practice to stay current. Real-life example: a junior lawyer mentored by a senior partner learns not only legal doctrine but also client management, billing practices, and firm politics. This accelerates professional growth. Similarly, active participation in a bar association's technology section keeps a lawyer informed about emerging legal tech trends. Practical application: lawyers seek mentors, join professional organizations, and create learning plans. Students practice networking skills, draft mentorship requests, and develop CLE strategies. They learn to balance billable work with professional development. 2. Advanced skills, strategy, management, and innovation. 2.1 Strategic thinking, case theory, risk assessment, and decision-making. Advanced practice requires strategic thinking beyond tactical execution. Lawyers must develop case theories that align facts, law, and client objectives, assess risks, legal, financial, reputational, and make informed decisions under uncertainty. Case theory: a coherent narrative explaining why the client should prevail, guiding all advocacy decisions. Risk assessment: evaluating likelihood and impact of adverse outcomes, including litigation risks, settlement values, and non-legal consequences. Decision-making: choosing among options, e.g., file suit versus negotiate, appeal versus accept, based on strategic analysis. Real-life example: in high-stakes litigation, a lawyer might develop a case theory emphasizing the opponent's bad faith to justify punitive damages. Risk assessment might reveal that trial could take years and cost millions, making settlement attractive despite a strong legal position. Strategic decision-making balances these factors. Practical application: lawyers use decision trees, cost-benefit analysis, and client counseling to guide strategy. Students practice developing case theories and conducting risk assessments. They learn to communicate strategic options clearly to clients. 2.2 Practice management, business development, financial management, and team leadership. Lawyers, especially in private practice, must manage the business aspects of law, attracting clients, managing finances, and leading teams. Business development, marketing, networking, and relationship building to generate work. Financial management, budgeting, billing, collections, and profitability analysis. Team leadership, delegating tasks, mentoring staff, and fostering collaboration. Real-life example: a solo practitioner who neglects business development may struggle to maintain a client base despite excellent legal skills. Conversely, a lawyer who masters financial management can invest in technology and staff, enhancing service quality and firm growth. Practical application: lawyers create business plans, track key performance indicators, and implement leadership practices. Students practice drafting marketing materials, analyzing financial statements, and conducting performance reviews. They learn to balance legal excellence with business acumen. 2.3 Innovation and technology, legal tech, process improvement, and alternative service models. The legal profession is transforming through technology and innovation. Lawyers who embrace legal tech, process improvement, and alternative service models gain competitive advantages. Legal tech, tools for research, AI-assisted, document automation, e-discovery, and client communication. Process improvement, Lean, Six Sigma, and project management techniques to enhance efficiency and quality. Alternative service models, virtual law firms, unbundled services, and legal process outsourcing. Real-life example, a firm that adopts document automation for routine contracts can reduce drafting time by 80%, freeing lawyers for higher-value work. Similarly, a virtual law firm can serve clients nationwide with lower overhead, offering competitive pricing. Practical application, lawyers evaluate and implement legal tech solutions, map and improve workflows, and experiment with new service models. Students practice using legal tech tools, conducting process audits, and designing alternative service offerings. They learn to innovate while maintaining ethical standards. 3. Complex matters, multi-jurisdictional, multi-party, and cross-border practice. 3.1 Multi-jurisdictional practice, licensing, choice of law, and coordination. Lawyers increasingly handle matters spanning multiple jurisdictions. This requires understanding licensing rules, pro hac vice admission, choice of law principles, and coordination with local counsel. Licensing, rules vary on temporary practice, pro hac vice admission, and multi-jurisdictional firms. Choice of law, determining which jurisdiction's law applies to substantive issues. Coordination, working effectively with local counsel to navigate procedural and cultural differences. Real-life example, a multinational merger may require coordination among lawyers in the US, EU, and Asia, each advising on local antitrust, corporate, and employment laws. Choice of law clauses in the merger agreement determine which law governs interpretation. Practical application, lawyers research jurisdictional requirements, draft choice of law provisions, and establish communication protocols with local counsel. Students practice analyzing multi-jurisdictional scenarios and drafting coordination agreements. They learn to manage cross-border complexity. 3.2 Multi-party and complex litigation, class actions, MDL, and consolidation. Complex matters often involve numerous parties and claims. Class actions, multi-district litigation, MDL, and consolidation require specialized procedural knowledge and management skills. Class actions, requirements of numerosity, commonality, typicality, and adequacy, certification strategies, settlement approval. MDL, centralization of related cases for pretrial proceedings, coordination among hundreds of lawyers. Consolidation, joining related cases for efficiency, managing conflicting interests. Real-life example, in pharmaceutical MDLs, thousands of plaintiffs allege harm from a drug. Lawyers must coordinate discovery, bellwether trials, and settlement negotiations while managing client expectations and ethical obligations. Practical application, lawyers develop case management plans, lead or participate in steering committees, and communicate with large client groups. Students practice drafting class certification motions and analyzing MDL procedures. They learn to manage scale and complexity. 3.3 Cross-border transactions and disputes, international contracts, arbitration, and enforcement. Global commerce requires navigating cross-border legal issues. Lawyers draft international contracts, advise on arbitration clauses, and enforce judgments across borders. International contracts, choice of law, forum selection, currency, and cultural considerations. Arbitration, advantages, neutrality, enforceability under New York Convention, and limitations, limited appeal, costs. Enforcement, recognizing and enforcing foreign judgments and arbitral awards. Real-life example, a cross-border supply contract might specify English law, arbitration in Singapore, and payment in euros. If a dispute arises, the lawyer must navigate arbitration rules, enforceability issues, and potential challenges in multiple jurisdictions. Practical application, lawyers draft international agreements, advise on dispute resolution clauses, and handle enforcement proceedings. Students practice analyzing cross-border scenarios and drafting arbitration clauses. They learn to balance global efficiency with local compliance. 4. contemporary issues and professional preparation. 4.1 Well-being and sustainability, mental health, work-life integration, and professional fulfillment. The legal profession faces well-being challenges, high stress, long hours, and mental health issues. Advanced practice requires strategies for sustainability. Mental health, recognizing signs of burnout, depression, and substance abuse, accessing resources. Work-life integration, setting boundaries, delegating, and prioritizing personal well-being. Professional fulfillment, aligning practice with values, finding meaning in work, and contributing to the profession. Real-life example, law firms that implement well-being programs, flexible schedules, counseling access, mindfulness training, report higher retention and satisfaction. Individual lawyers who prioritize self-care sustain longer, more fulfilling careers. Practical application, lawyers develop personal well-being plans, advocate for firm policies, and support colleagues. Students practice stress management techniques and reflect on career values. They learn to balance ambition with sustainability. 4.2 Access to justice and pro bono, ethical obligations and practical strategies. Lawyers have an ethical responsibility to improve access to justice. Pro bono service, simplified procedures, and technology can expand access. Pro bono, providing free legal services to those unable to pay, often required or encouraged by bar associations. Simplified procedures, unbundled services, online forms, and self-help resources for pro se litigants. Technology, online dispute resolution, legal chatbots, and document automation to reduce costs. Real-life example, legal aid organizations use technology to serve more clients with limited resources. Law firms that integrate pro bono into practice culture attract talent and enhance reputation. Practical application, lawyers incorporate pro bono into practice, support access initiatives, and leverage technology for efficiency. Students practice providing limited scope representation and developing access-focused solutions. They learn to serve diverse communities effectively. 4.3 Learning outcomes and competency benchmarks. By completing advanced legal practice, students should be able to integrate knowledge across substantive areas for complex matters. Develop specialization or generalism strategies aligned with career goals. Manage practice business aspects and lead teams effectively. Navigate multi-jurisdictional, multi-party, and cross-border challenges. Prioritize well-being and access to justice in professional practice. Practical application, these outcomes prepare students for leadership roles in the legal profession. Mastery ensures long-term success and impact. 4.4 Assessment methods, strategic plans, case studies, and practice simulations. Assessments include strategic plans, develop career or firm development strategies. Case studies, analyze complex, multi-issue matters. Practice simulations, manage virtual law firms or complex litigation. Real-life example, a final project might involve creating a business plan for a new legal practice area, incorporating market analysis, financial projections, and ethical considerations. This mirrors entrepreneurial practice development. Practical application, students should practice strategic thinking and practical application. 4.5 Transition to capstone and beyond, advanced practice as foundation for professional excellence. Advanced legal practice prepares students for the capstone project and entry into the profession. Capstone project integrates learning in a substantial, self-directed work product. Professional entry equips students with skills for immediate practice contribution. Lifelong development establishes habits for continuous growth. Practical application, students should view advanced practice as a launchpad. Mastery ensures readiness for professional challenges. Slide 10. Year 4, Semester 1, Advanced Legal Practice. Course, Law.403, Law and Society. Foundations of Law and Society, Theoretical Perspectives and Methodologies. 1.1 Law as a Social Institution, functions, legitimacy, and change. Law does not operate in a vacuum, it is embedded in social, economic, and political contexts. Understanding law as a social institution requires examining its functions, order, justice, liberty, sources of legitimacy, consent, coercion, tradition, and mechanisms of change, legislation, litigation, social movements. Functions: law coordinates behavior, resolves disputes, distributes resources, and expresses societal values. Legitimacy: law is obeyed not merely due to coercion but because it is perceived as legitimate. Legitimacy derives from procedural fairness, substantive justice, and democratic accountability. Change: law evolves through formal processes, legislation, adjudication, and informal pressures, social movements, cultural shifts. Real-life example: the civil rights movement transformed U.S. law through litigation, Brown v. Board, legislation, Civil Rights Act, and cultural change. This illustrates how social forces drive legal evolution. Conversely, law shapes society. Anti-discrimination laws alter workplace norms and individual attitudes. Practical application: lawyers advising on policy or advocacy must understand the social context of legal rules. Students analyze how law both reflects and shapes social values. They practice identifying leverage points for legal change. 1.2 Theoretical frameworks: functionalism, conflict theory, and critical perspectives. Scholarly perspectives offer different lenses for analyzing law-society relationships. Functionalism views law as maintaining social order and integration. Emphasizes stability and consensus. Conflict theory views law as a tool of power, serving dominant groups. Emphasizes inequality and struggle. Critical perspectives include critical legal studies, law is indeterminate, feminist jurisprudence, law reflects gender bias, and critical race theory, law perpetuates racial hierarchy. Real-life example: a functionalist might view contract law as facilitating commerce and trust. A conflict theorist might view the same rules as favoring capital over labor. A critical race scholar might examine how neutral contract doctrines produce racially disparate outcomes. Practical application: lawyers use theoretical frameworks to diagnose problems and design interventions. Students practice applying different perspectives to the same legal issue. They learn to critique and synthesize theoretical insights. 1.3 Methodologies: empirical research, comparative analysis, and interdisciplinary approaches. Studying law and society requires diverse methodologies. Empirical research: quantitative, surveys, statistics, and qualitative, interviews, ethnography, methods to examine law's effects. Comparative analysis: comparing legal systems or policies across jurisdictions to identify patterns and lessons. Interdisciplinary approaches: drawing on sociology, economics, political science, anthropology, and psychology to enrich legal analysis. Real-life example: research on mandatory minimum sentencing uses empirical data to assess impacts on incarceration rates and racial disparities. Comparative analysis of drug policies across countries informs reform debates. Interdisciplinary approaches combine legal doctrine with economic modeling or sociological theory. Practical application: lawyers use empirical evidence in litigation, e.g., statistical proof of discrimination, and policy advocacy. Students practice research design, data analysis, and interdisciplinary synthesis. They learn to evaluate empirical claims critically. 2. Law and social inequality: race, class, gender, and power. 2.1 Race and law: structural racism, criminal justice, and civil rights. Law has both perpetuated and challenged racial inequality. Structural racism refers to laws, policies, and practices that produce racial disparities regardless of individual intent. Criminal justice: racial disparities in policing, charging, sentencing, and incarceration. Civil rights: anti-discrimination laws, affirmative action, and voting rights. Property and wealth: historical exclusion from property ownership, redlining, and wealth gaps. Real-life example: In McCleskey v. Kemp, 1987, the Supreme Court acknowledged statistical evidence of racial disparities in capital sentencing but held it insufficient to prove unconstitutional discrimination in individual cases. This illustrates the tension between systemic analysis and individual adjudication. Practical application: lawyers litigate discrimination claims, advocate for policy reform, and advise clients on compliance. Students analyze empirical evidence of racial disparities and evaluate legal responses. They practice developing race-conscious legal strategies. 2.2 Class and Law, Access to Justice, Economic Regulation, and Wealth Distribution. Law shapes economic inequality through rules governing property, contracts, labor, and taxation. Access to justice, barriers to legal representation for low-income individuals, civil Gideon debates. Economic regulation, antitrust, consumer protection, and labor laws that balance market freedom with fairness. Wealth distribution, tax policy, social welfare programs, and inheritance laws that affect inequality. Real-life example: the rise of mandatory arbitration clauses in consumer and employment contracts limits access to courts for low-income individuals, illustrating how procedural rules affect substantive rights. Practical application: lawyers provide pro bono services, advocate for legal aid funding, and design accessible legal processes. Students analyze barriers to justice and evaluate reform proposals. They practice developing class-conscious legal strategies. 2.3 Gender and Law, Equality, Autonomy, and Structural Change. Law has both constrained and advanced gender equality. Issues include reproductive rights, workplace discrimination, family law, and violence against women. Equality, formal equality, same treatment, versus substantive equality, equitable outcomes. Autonomy, rights to bodily integrity, reproductive choice, and freedom from coercion. Structural change, addressing systemic biases in legal doctrines and institutions. Real-life example: in Ledbetter v. Goodyear Tire and Rubber Company, 2007, the Supreme Court limited pay discrimination claims due to statutes of limitations, prompting legislative override, Lilly Ledbetter Fair Pay Act. This illustrates how legal rules interact with social realities. Practical application: lawyers litigate gender discrimination cases, advise on workplace policies, and advocate for legislative change. Students analyze gender impacts of legal rules and evaluate equality strategies. They practice developing gender-conscious legal arguments. 3. Law and social change, movements, litigation, and policy. 3.1 Social movements and legal strategy, from protest to policy. Social movements use law as a tool for change. Strategies include impact litigation, legislative advocacy, and cultural persuasion. Impact litigation, strategic cases designed to establish precedent or shift public opinion. Legislative advocacy, drafting bills, lobbying, and mobilizing constituents. Cultural persuasion, using media, art, and education to change attitudes. Real-life example: the marriage equality movement combined litigation, Obergefell, legislative campaigns, and cultural advocacy to achieve nationwide recognition. This illustrates the synergy of legal and social strategies. Practical application: lawyers collaborate with movements, providing legal expertise while respecting grassroots leadership. Students practice developing movement-aligned legal strategies. They learn to balance legal tactics with broader social goals. 3.2 Litigation as social reform, strengths, limitations, and ethical considerations. Litigation can drive social change but has limitations. Courts are reactive, incremental, and dependent on enforcement. Strengths: precedent, national reach, and symbolic power. Limitations: narrow standing, political backlash, and implementation challenges. Ethical considerations: representing groups versus individuals, managing client expectations, avoiding co-optation. Real-life example: school desegregation litigation after Brown faced massive resistance, requiring decades of enforcement efforts. This illustrates litigation's potential and limits as a reform tool. Practical application. Lawyers assess when litigation is appropriate and design cases with implementation in mind. Students practice evaluating reform strategies and ethical dilemmas. They learn to integrate litigation with other tactics. 3.3 Policy advocacy and legislative drafting, from idea to implementation. Policy advocacy translates social goals into legal rules. This requires understanding legislative processes, drafting skills, and coalition building. Legislative process, committee review, floor debate, amendment, and enactment. Drafting skills, clear language, enforceable provisions, and political feasibility. Coalition building, engaging stakeholders, building public support, and negotiating compromises. Real-life example, the Affordable Care Act involved years of drafting, negotiation, and advocacy. Its complex structure reflects political compromises and policy trade-offs. Practical application, lawyers draft legislation, testify before committees, and mobilize support. Students practice legislative drafting and advocacy simulations. They learn to navigate political constraints. 4. Contemporary issues and professional preparation. 4.1 Technology and society, digital divides, surveillance, and algorithmic governance. Technology transforms law-society relationships. Digital divides exacerbate inequality, surveillance challenges privacy, algorithms automate decisions with bias risks. Digital divides, unequal access to technology and digital literacy. Surveillance, government and corporate monitoring of communications and behavior. Algorithmic governance, automated decision-making in criminal justice, employment, and benefits. Real-life example, predictive policing algorithms may perpetuate racial biases in law enforcement, illustrating how technology can encode inequality. Legal responses include impact assessments and transparency requirements. Practical application, lawyers advise on technology policy, litigate digital rights cases, and design equitable tech solutions. Students analyze technology's social impacts and evaluate regulatory approaches. They practice developing tech-conscious legal strategies. 4.2 Globalization and transnational justice, human rights, climate, and migration. Global challenges require transnational legal responses. Human rights norms, climate agreements, and migration policies intersect with domestic law. Human rights, international treaties and tribunals influencing domestic practice. Climate, international agreements, Paris Accord, and domestic implementation. Migration, cross-border movement, refugee protection, and citizenship debates. Real-life example, climate litigation uses human rights frameworks to hold governments accountable for emissions, illustrating the convergence of global norms and domestic advocacy. Practical application, lawyers navigate transnational legal frameworks, represent clients in international forums, and advocate for global justice. Students analyze transnational issues and evaluate governance mechanisms. They practice developing globally conscious legal strategies. 4.3 Learning outcomes and competency benchmarks. By completing law and society, students should be able to analyze law-society relationships using theoretical and empirical methods. Evaluate law's role in producing and addressing social inequality. Design legal strategies for social change. Address contemporary challenges, technology, globalization. Practical application, these outcomes prepare students for public interest law, policy advocacy, and socially conscious practice. Mastery ensures impactful legal work. 4.4 Assessment methods, research papers, policy briefs, and advocacy simulations. Assessments include research papers, empirical or theoretical analysis of law-society issues. Policy briefs, recommendations for legislative or regulatory reform. Advocacy simulations, role-play movement lawyering or policy advocacy. Real-life example, a final project might involve drafting a policy brief on algorithmic fairness, combining legal analysis, empirical evidence, and advocacy strategy. This mirrors real-world policy work. Practical application: students should practice research, writing, and advocacy skills. 4.5 Transition to capstone and beyond: law and society as foundation for impactful practice. Law and society prepares students for the capstone project and careers focused on social impact. Capstone project integrates law society analysis in a substantial work product. Professional entry equips students to address complex social legal challenges. Lifelong impact establishes a commitment to justice and equity. Practical application: students should view law as a tool for social change. Mastery ensures meaningful professional contribution. Slide 10. Year 4, Semester 1, Advanced Legal Practice. Course, Law.404, Gender and Law. Foundations of Gender and Law, Theoretical Frameworks and Historical Context. 1.1 Feminist Legal Theory, Liberal, Radical, Intersectional, and Postmodern Perspectives. Feminist legal theory provides critical frameworks for analyzing how law constructs and regulates gender. Different strands offer distinct insights and strategies. Liberal feminism focuses on formal equality, removing legal barriers to women's participation in public life. Emphasizes anti-discrimination laws and equal opportunity. Radical feminism views gender inequality as rooted in patriarchal power structures. Focuses on issues like sexual violence, reproductive rights, and the public-private divide. Intersectional feminism, coined by Kimberly Crenshaw, emphasizes how gender intersects with race, class, sexuality, and other identities to produce compounded disadvantage. Postmodern feminism questions stable categories of woman and man, emphasizing fluidity and the discursive construction of gender. Real-life example: in United States v. Virginia, 1996, the Supreme Court applied intermediate scrutiny to strike down the male-only admissions policy at VMI. Liberal feminist arguments emphasizing equal opportunity prevailed, while radical feminist critiques of militarism and masculinity were less visible. Intersectional analysis would examine how the policy affected women of color differently. Practical application: lawyers use feminist theories to frame arguments, critique doctrines, and design interventions. Students practice applying different feminist perspectives to the same legal issue. They learn to synthesize theoretical insights for practical advocacy. 1.2 Historical evolution, from coverture to constitutional equality. Gender and law have evolved through distinct historical phases, each reflecting changing social norms and political struggles. Coverture: under English common law, married women had no separate legal identity, their rights were subsumed by their husbands. Suffrage and reform: the 19th and early 20th centuries saw campaigns for voting rights, property rights, and access to education and professions. Second wave feminism: the 1960s to 1980s focused on workplace equality, reproductive rights, and ending gender-based violence. Contemporary debates: transgender rights, #MeToo, and global gender justice. Real-life example: the 19th Amendment, 1920, granted women suffrage, but voting rights for women of color were not fully secured until the Voting Rights Act, 1965. This illustrates the intersection of gender and race in legal history. Practical application: lawyers advising on gender issues must understand historical context to interpret current doctrines and advocate for reform. Students analyze historical cases and statutes to trace doctrinal evolution. They learn to use history strategically in advocacy. 1.3 International and comparative perspectives, global norms and local realities. Gender equality is a global concern, with international norms influencing domestic law. International norms: CEDAW, Convention on the Elimination of All Forms of Discrimination Against Women, Beijing Platform, and regional treaties. Comparative approaches: different jurisdictions adopt varying strategies for gender equality, e.g., quotas, anti-discrimination laws, constitutional provisions. Local realities: cultural, religious, and economic factors shape implementation of gender norms. Real-life example: Rwanda's constitutional gender quotas have resulted in the world's highest percentage of women in parliament, illustrating how legal design can advance representation. Conversely, in some jurisdictions, customary law conflicts with statutory gender equality provisions. Practical application: lawyers working on gender issues must navigate international norms and local contexts. Students practice comparative analysis and evaluate transnational advocacy strategies. They learn to balance universal principles with cultural sensitivity. 2. Substantive areas: employment, family, reproductive rights, and violence. 2.1 Employment and economic equality, discrimination, pay equity, and work-life balance. Gender inequality persists in the workplace through discrimination, pay gaps, and unequal care responsibilities. Discrimination: Title VII prohibits sex discrimination in employment, including hiring, promotion, and harassment. Pay equity: Equal Pay Act and state laws address wage disparities, comparable worth debates continue. Work-life balance: family and medical leave, flexible work arrangements, and childcare support affect women's economic participation. Real-life example: in Ledbetter v. Goodyear, 2007, the Supreme Court limited pay discrimination claims due to statutes of limitations, prompting the Lilly Ledbetter Fair Pay Act. This illustrates how legal rules interact with workplace realities. Practical application: lawyers litigate discrimination claims, advise on compliance, and advocate for policy reform. Students analyze pay equity data and evaluate workplace policies. They practice developing gender-conscious employment strategies. 2.2 Family law and gender: marriage, divorce, custody, and care work. Family law regulates intimate relationships and care responsibilities, with profound gender implications. Marriage and partnership: legal recognition of same-sex marriage, domestic partnerships, and polyamorous relationships. Divorce and property: equitable distribution versus community property, alimony and its gendered impacts. Custody and care: best interest standards, presumptions, e.g., tender years doctrine, and the devaluation of care work. Real-life example: in Obergefell v. Hodges, 2015, the Supreme Court recognized same-sex marriage, expanding family law's inclusivity. However, custody disputes in LGBTQ+ families still face bias in some jurisdictions. Practical application: lawyers advise on family formation, dissolution, and custody. Students analyze gendered assumptions in family law doctrines. They practice developing inclusive family law strategies. 2.3 Reproductive rights and autonomy: contraception, abortion, and assisted reproduction. Reproductive rights are central to gender equality, involving bodily autonomy, health, and social participation. Contraception: access to birth control affects women's economic and educational opportunities. Abortion: legal restrictions impact health, autonomy, and equality. Debates involve morality, federalism, and rights. Assisted reproduction, IVF, surrogacy, and genetic technologies raise questions of parentage, access, and regulation. Real-life example: in Dobbs v. Jackson Women's Health Organization, 2022, the Supreme Court overturned Roe v. Wade, returning abortion regulation to states. This created a patchwork of laws, with profound gender and equity implications. Practical application: lawyers litigate reproductive rights cases, advise clinics and patients, and advocate for policy change. Students analyze constitutional and statutory frameworks. They practice developing rights-based reproductive strategies. 2.4 Gender-based violence, domestic violence, sexual assault, and legal responses. Gender-based violence is a pervasive human rights issue with complex legal dimensions. Domestic violence, civil protection orders, criminal prosecution, and survivor services. Sexual assault, consent standards, evidence rules, and trauma-informed practices. Systemic responses, VAWA, Violence Against Women Act, campus sexual misconduct policies, and international accountability. Real-life example: in United States v. Morrison, 2000, the Supreme Court limited federal civil remedies for gender-motivated violence, illustrating federalism constraints on gender justice. Practical application: lawyers represent survivors, advocate for policy reform, and train professionals on trauma-informed practices. Students analyze legal responses to gender-based violence. They practice developing survivor-centered strategies. 3. Contemporary issues and professional preparation. 3.1 Transgender rights and gender identity, legal recognition, discrimination, and inclusion. Transgender rights are at the forefront of gender and law debates, involving identity recognition, discrimination protection, and access to services. Legal recognition: name and gender marker changes on identity documents, birth certificate amendments. Discrimination protection: Title VII, Title IX, and state laws prohibiting gender identity discrimination. Access to services: healthcare, sports participation, and public accommodations. Real-life example: in Bostock v. Clayton County, 2020, the Supreme Court held that Title VII prohibits discrimination based on sexual orientation and gender identity, expanding employment protections. However, state-level debates on transgender youth healthcare and sports participation continue. Practical application: lawyers advise transgender clients on identity recognition, litigate discrimination claims, and advocate for inclusive policies. Students analyze emerging legal frameworks. They practice developing identity-affirming legal strategies. 3.2 Intersectionality in practice: race, class, disability, and gender. Intersectional analysis is essential for effective gender advocacy, recognizing that gender inequality intersects with other forms of disadvantage. Race and gender: Black feminist thought, reproductive justice, and criminalization. Class and gender: economic inequality, care work, and access to justice. Disability and gender: accessibility, autonomy, and representation. Real-life example: the reproductive justice framework, developed by women of color, expands beyond abortion rights to include the right to have children, not have children, and parent in safe environments. This illustrates intersectional advocacy. Practical application: lawyers apply intersectional analysis to case strategy, policy design, and movement building. Students practice identifying intersecting oppressions and developing inclusive solutions. They learn to center marginalized voices. 3.3 Learning outcomes and competency benchmarks. By completing gender and law, students should be able to analyze gender issues using feminist legal theories, navigate substantive areas, employment, family, reproductive rights, violence, address contemporary challenges, transgender rights, intersectionality, develop gender-conscious legal strategies. Practical application: these outcomes prepare students for gender-focused practice, policy advocacy, and inclusive lawyering. Mastery ensures effective representation of diverse clients. 3.4 Assessment methods: case analyses, policy proposals, and advocacy projects. Assessments include: case analyses, evaluate gender dimensions of landmark decisions. Policy proposals, draft legislation or regulations addressing gender inequality. Advocacy projects, design campaigns or litigation strategies for gender justice. Real-life example: a final project might involve drafting a model policy for workplace accommodations for transgender employees, combining legal analysis, empirical evidence, and advocacy strategy. This mirrors real-world policy work. Practical application: students should practice research, writing, and advocacy skills. 3.5 Transition to capstone and beyond: gender and law as foundation for inclusive practice. Gender and law prepares students for the capstone project and careers focused on equity and inclusion. Capstone project integrates gender analysis in a substantial work product. Professional entry equips students to address gender issues in any practice area. Lifelong commitment establishes a dedication to gender justice. Practical application: students should view gender as a critical lens for all legal work. Mastery ensures inclusive and effective practice. Slide 10. Year 4, Semester 1, Advanced Legal Practice. Course, Law.405, property rights. Foundations of property rights, theoretical perspectives and constitutional protection. 1.1 The nature of property, bundles of rights, social relations, and economic functions. Property law governs relationships between persons with respect to things. Understanding theoretical foundations informs interpretation and reform. Bundle of rights theory, property as a collection of entitlements, right to possess, use, exclude, transfer, and destroy. These sticks may be separated, e.g., leases, easements. Social relations theory, property as a web of relationships among people regarding resources, emphasizing duties and community values. Economic theory, property as a mechanism for efficient resource allocation, incentivizing investment and reducing transaction costs. Real-life example, in Johnson v. Mintosh, 1823, the U.S. Supreme Court held that Native American tribes had rights of occupancy but not full title to land, illustrating how property concepts reflect power dynamics and colonial history. Practical application, lawyers must identify which property rights are at issue in disputes. Understanding theoretical perspectives helps craft arguments for or against particular allocations, e.g., eminent domain, regulatory takings. Students analyze cases through different theoretical lenses. 1.2 Constitutional protection, takings, due process, and equal protection. The 5th and 14th Amendments protect property rights against government interference. Takings clause, private property shall not be taken for public use without just compensation. Includes physical takings and regulatory takings. Due process, procedural due process requires notice and hearing before deprivation. Substantive due process protects fundamental property interests. Equal protection, property regulations must not discriminate based on suspect classifications. Real-life example, in Penn Central Transportation Company v. New York City, 1978, the Supreme Court upheld landmark preservation regulations as not constituting a taking, applying a balancing test of economic impact, investment-backed expectations, and character of government action. This illustrates the complexity of regulatory takings analysis. Practical application, lawyers advise clients on regulatory compliance and challenge unconstitutional takings. Students practice applying takings tests to fact patterns. They learn to balance public interests with private rights. 1.3 Historical and comparative perspectives, evolution and variation. Property doctrines evolve through historical processes and vary across jurisdictions. Historical evolution, from feudal tenure to modern fee simple, from common law to statutory reforms. Comparative variation, civil law systems emphasize codified property rules, common law systems rely on precedent and equity. Real-life example, the Torrens system of title registration, used in Australia and some U.S. states, simplifies property transfers compared to the traditional recording system. This illustrates how institutional design affects property rights. Practical application, lawyers practicing in multiple jurisdictions must understand comparative property rules. Students analyze historical and comparative materials to inform advocacy. They learn to adapt strategies to different legal cultures. 2. Substantive doctrines, acquisition, transfer, and limitations. 2.1 Acquisition of property, possession, creation, and transfer. Property rights originate through various methods. Possession, physical control with intent to claim ownership. First possession often establishes title. Creation, intellectual property, newly discovered resources, and artificial creations. Transfer, voluntary, sale, gift, and involuntary, inheritance, foreclosure, transfers. Real-life example, in Pearson v. Post, 1805, the court held that mere pursuit of a fox did not constitute possession, physical capture or mortal wounding was required. This illustrates the certainty rationale behind possession rules. Practical application, lawyers advise clients on acquiring property rights through purchase, inheritance, or adverse possession. Students practice analyzing acquisition scenarios. They learn to document and perfect property interests. 2.2 Estates and future interests, duration, quality, and classification. Property law recognizes various durations and qualities of ownership. Present estates, fee simple absolute, life estate, leasehold. Future interests, reversions, remainders, executory interests. Rule against perpetuities, future interests must vest, if at all, within life and being plus 21 years. Real-life example, in White v. Brown, 1947, a will granting property, to my sister for her life, then to her children, created a life estate with remainder, illustrating future interest creation. Practical application, lawyers draft deeds and wills to create specific estates. Students practice classifying estates and future interests. They learn to avoid perpetuities violations. 2.3 Land use controls, private and public regulation. Property rights are limited by private agreements and public regulation. Servitudes, easements, covenants, and equitable servitudes that burden land for the benefit of other land or persons. Zoning and land use regulation, police power regulations promoting health, safety, and welfare. Environmental constraints, wetlands, endangered species, and climate regulations affecting property use. Real-life example, in Village of Euclid v. Ambler Realty Company, 1926, the Supreme Court upheld zoning as a valid exercise of police power, establishing the foundation for modern land use regulation. Practical application, lawyers navigate zoning approvals, challenge regulatory takings, and draft servitude agreements. Students analyze land use controls and their impacts. They learn to balance development with community interests. 3. Contemporary issues, digital property, environmental rights, and indigenous claims. 3.1 Digital property and intellectual assets, virtual goods, data, and code. Technology creates new forms of property requiring legal recognition. Virtual property, in-game items, digital currencies, and virtual real estate. Data as property, personal data, business data, and government data, ownership and control debates. Code and algorithms, software, AI models, and automated systems as property interests. Real-life example, in Bravado International v. Mainstream Publishing, 1996, courts address trademark rights in domain names, illustrating how traditional property doctrines adapt to digital contexts. Practical application, lawyers advise on digital asset transactions, data privacy compliance, and IP protection for software. Students analyze emerging property concepts. They learn to apply traditional doctrines to novel contexts. 3.2 Environmental property rights, conservation, climate, and sustainability. Property law intersects with environmental protection through various mechanisms. Conservation easements, voluntary restrictions on development to protect natural resources. Public trust doctrine, government holds certain resources, navigable waters, shores, in trust for public use. Climate rights, emerging claims that property rights include protection from climate harms. Real-life example, in National Audubon Society v. Superior Court, 1983, the California Supreme Court applied the public trust doctrine to protect Mono Lake from water diversions, illustrating how property rights accommodate environmental values. Practical application, lawyers draft conservation agreements, litigate public trust claims, and advise on climate risk. Students analyze environmental property doctrines. They learn to integrate sustainability into property practice. 3.3 Indigenous and communal property, recognition, reconciliation, and reform. Indigenous and communal property systems challenge individualistic property norms. Indigenous land claims, recognition of Aboriginal title, treaty rights, and self-governance. Communal property, cooperative ownership, community land trusts, and commons management. Reconciliation efforts, legal reforms to address historical dispossession and promote equity. Real-life example, in Mabwa v. Queensland, No. 2, 1992, the Australian High Court recognized native title, overturning the doctrine of terra nullius and illustrating property law's capacity for reform. Practical application, lawyers represent indigenous communities in land claims, advise on communal ownership structures, and advocate for legal recognition. Students analyze indigenous property systems. They learn to respect cultural diversity in property law. 4. Contemporary issues and professional preparation. 4.1 Property rights in crisis, displacement, disaster, and development. Property rights face challenges in contexts of crisis and change. Displacement, eminent domain, gentrification, and forced evictions. Disaster, property damage, insurance claims, and reconstruction rights. Development, balancing economic growth with community preservation. Real-life example, post-Katrina property disputes in New Orleans involved complex issues of abandonment, insurance, and redevelopment rights, illustrating property law in crisis contexts. Practical application, lawyers advise clients on property rights in crisis situations, litigate displacement claims, and advocate for equitable recovery. Students analyze crisis scenarios. They learn to navigate urgency and complexity. 4.2 Globalization and transnational property, cross-border investment and dispute resolution. Globalization creates transnational property issues requiring cross-border legal strategies. Cross-border investment, foreign ownership restrictions, investment treaties, and expropriation claims. Dispute resolution, international arbitration, forum selection, and judgment enforcement. Harmonization efforts, model laws, treaties, and soft law instruments. Real-life example, Investor-State Dispute Settlement, ISDS, under trade agreements allows foreign investors to challenge government regulations as expropriation, illustrating tensions between property rights and regulatory autonomy. Practical application, lawyers advise on cross-border property transactions, represent clients in international arbitration, and navigate treaty protections. Students analyze transnational property issues. They learn to manage jurisdictional complexity. 4.3 Learning outcomes and competency benchmarks. By completing property rights, students should be able to analyze property concepts using theoretical and doctrinal frameworks, navigate acquisition, transfer, and limitation doctrines, address contemporary issues, digital, environmental, indigenous, advise on property rights in crisis and global contexts. Practical application, these outcomes prepare students for real estate, land use, and environmental practice. Mastery ensures effective property advocacy. 4.4 Assessment methods, title analysis, regulatory review, and policy proposals. Assessments include title analysis, evaluate property ownership and encumbrances. Regulatory review, assess land use and environmental regulations. Policy proposals, draft reforms addressing contemporary property issues. Real-life example, a final project might involve advising a community on resisting gentrification through legal tools like community land trusts and inclusionary zoning. This mirrors real-world advocacy. Practical application, students should practice doctrinal analysis and policy development. 4.5 Transition to capstone and beyond, property rights as foundation for specialized practice. Property rights prepares students for the capstone project and careers in real estate, land use, and environmental law. Capstone project, integrates property analysis in a substantial work product. Professional entry, equips students to handle complex property matters. Lifelong relevance, property law underpins wealth, community, and sustainability. Practical application, students should view property as a foundational legal concept. Mastery ensures versatile and impactful practice. Slide 10. Year 4, Semester 1, Advanced Legal Practice. Course, Law.406, Law of the Sea. Foundations of the Law of the Sea, Historical Evolution and Conventional Framework. 1.1 Historical Development, from freedom of the seas to comprehensive regulation. The law of the sea has evolved from early doctrines of freedom to a comprehensive regulatory regime balancing state sovereignty, resource rights, and global commons. Freedom of the seas, Hugo Grotius's Mare Liberum, 1609, argued for open oceans, influencing early international law. Territorial claims. Coastal states gradually asserted control over adjacent waters for security and resource management. UNCLOS. The United Nations Convention on the Law of the Sea, 1982, established a comprehensive framework, often called the Constitution for the Oceans. Real-life example. The Caroline Incident, 1837, between the U.S. and Britain involved cross-border maritime enforcement, illustrating early tensions between freedom of the seas and coastal state authority. UNCLOS later codified rules for such scenarios. Practical application. Lawyers advising on maritime issues must understand historical context to interpret current doctrines. Students analyze historical cases and treaties to trace doctrinal evolution. They learn to use history strategically in advocacy. 1.2 UNCLOS Framework, Zones, Rights, and Obligations. UNCLOS divides the ocean into zones with distinct legal regimes. Territorial sea, up to 12 nautical miles from baseline, coastal state has sovereignty subject to innocent passage. Exclusive Economic Zone, EEZ up to 200 nautical miles, coastal state has sovereign rights over resources. High seas, beyond national jurisdiction, freedom of navigation, fishing, and research. The area, seabed beyond national jurisdiction, resources are the common heritage of mankind. Real-life example, in the South China Sea Arbitration, 2016, the tribunal interpreted UNCLOS provisions on maritime entitlements, rejecting China's 9-line claim as inconsistent with the convention. This illustrates UNCLOS's role in dispute resolution. Practical application. Lawyers advise states and private actors on maritime rights and obligations. Students practice applying UNCLOS provisions to fact patterns. They learn to navigate zone-based jurisdiction. 1.3 Institutional Architecture, ITLOs, ISA, and regional bodies. UNCLOS establishes institutions for implementation and dispute resolution. International Tribunal for the Law of the Sea, ITLOS adjudicates disputes concerning UNCLOS interpretation. International Seabed Authority, ISA regulates mineral resource activities in the area. Regional Fisheries Management Organizations, RFMOs manage fish stocks in specific regions. Real-life example, ITLOS's advisory opinion on seabed mining, 2011, clarified state responsibilities for environmental protection in the area, illustrating the tribunal's role in developing the law. Practical application. Lawyers represent clients before ITLOs, advise on ISA regulations, and engage with RFMOs. Students analyze institutional procedures and jurisprudence. They learn to navigate multiforum advocacy. 2. Substantive areas, navigation, resources, and environmental protection. 2.1 Navigation and maritime security, innocent passage, transit passage, and piracy. UNCLOS balances coastal state security with navigational freedoms. Innocent passage, ships may pass through territorial seas if not prejudicial to peace, good order, or security. Transit passage, unimpeded passage through straits used for international navigation. Piracy and maritime security, universal jurisdiction over piracy, cooperation to combat terrorism and smuggling. Real-life example, in MV Saiga, No. 2, 1999, ITLOS held that Guinea's arrest of a bunkering vessel in its EEZ violated UNCLOS, illustrating limits on coastal state enforcement. Practical application. Lawyers advise on passage rights, defend against unlawful arrests, and prosecute maritime crimes. Students analyze navigation scenarios. They learn to balance security and freedom. 2.2 Resource rights, fisheries, minerals, and energy. Marine resources are governed by distinct regimes based on location and type. Fisheries, coastal states manage stocks in EEZs, high seas fishing requires regional cooperation. Minerals, continental shelf resources belong to coastal states, area resources are managed by ISA. Energy, offshore oil, gas, and renewable energy development subject to environmental and safety regulations. Real-life example, disputes over Arctic resources involve overlapping continental shelf claims, illustrating the complexity of resource rights in changing environments. Practical application, lawyers negotiate resource agreements, litigate boundary disputes, and advise on regulatory compliance. Students analyze resource allocation scenarios. They learn to manage competing claims. 2.3 Marine environmental protection, pollution, biodiversity, and climate. UNCLOS and related treaties protect the marine environment. Pollution control, flag state, port state, and coastal state responsibilities for vessel source pollution. Biodiversity conservation, protection of marine species and habitats, including high seas areas beyond national jurisdiction. Climate change, ocean acidification, sea level rise, and coastal adaptation. Real-life example, the ITLO's Advisory Opinion on Climate Change, 2023, clarified state obligations to prevent marine pollution from greenhouse gas emissions, illustrating the intersection of climate and ocean law. Practical application, lawyers advise on environmental compliance, litigate pollution claims, and advocate for conservation. Students analyze environmental doctrines. They learn to integrate sustainability into maritime practice. 3. Dispute resolution and contemporary challenges. 3.1 Dispute settlement under UNCLOS, compulsory procedures and limitations. UNCLOS provides multiple dispute resolution mechanisms. Compulsory procedures, parties may choose ITLOS, ICJ, or arbitration, default is arbitration. Limitations, optional exceptions for military activities, law enforcement, and boundary delimitation. Provisional measures, ITLOS may order urgent measures to preserve rights or prevent environmental harm. Real-life example, in Arctic Sunrise, 2013, ITLOS ordered Russia to release a Greenpeace vessel and crew, illustrating provisional measures' role in protecting rights. Practical application, lawyers represent states and private actors in UNCLOS disputes. Students practice drafting submissions and analyzing jurisdictional issues. They learn to navigate compulsory procedures. 3.2 Emerging issues, deep seabed mining, marine genetic resources, and ocean governance. New challenges require legal adaptation. Deep seabed mining, ISA developing regulations for mineral extraction in the area, environmental concerns. Marine genetic resources, bioprospecting in areas beyond national jurisdiction, benefit sharing debates. Ocean governance, coordination among multiple treaties and institutions, integrated management approaches. Real-life example, negotiations for a BBNJ, biodiversity beyond national jurisdiction, treaty illustrate efforts to address governance gaps in high seas conservation. Practical application, lawyers advise on emerging regulations, participate in treaty negotiations, and advocate for sustainable governance. Students analyze emerging issues. They learn to shape legal development. 3.3 Geopolitical tensions, South China Sea, Arctic, and strategic competition. Maritime disputes often reflect broader geopolitical rivalries. South China Sea, overlapping claims, island building, and freedom of navigation operations. Arctic, melting ice opens new shipping routes and resource access, governance challenges. Strategic competition, naval presence, undersea cables, and dual-use technologies. Real-life example, U.S. freedom of navigation operations in the South China Sea challenge excessive maritime claims, illustrating the intersection of law and power. Practical application, lawyers advise governments and corporations on geopolitical risks. Students analyze strategic scenarios. They learn to navigate law-power dynamics. 4. Contemporary issues and professional preparation. 4.1 Technology and the law of the sea, autonomous vessels, surveillance, and data. Technology transforms maritime practice and regulation. Autonomous vessels, legal status, liability, and safety standards for unmanned ships. Surveillance and monitoring, satellite tracking, AIS data, and enforcement technologies. Data and information, marine scientific research, data sharing, and intellectual property. Real-life example, the IMO's ongoing work on regulations for maritime autonomous surface ships, MAS, illustrates legal adaptation to technological change. Practical application, lawyers advise on technology compliance, litigate liability issues, and advocate for adaptive regulation. Students analyze technology law intersections. They learn to manage innovation risks. 4.2 Equity and Justice, Developing States, Indigenous Rights, and Intergenerational Equity. The law of the sea must address distributive justice concerns. Developing states, capacity building, technology transfer, and equitable resource sharing. Indigenous rights, recognition of traditional maritime practices and knowledge. Intergenerational equity, sustainable use for future generations, precautionary approaches. Real-life example, unclosed provisions on equitable sharing of deep seabed mining revenues reflect distributive justice principles, though implementation remains challenging. Practical application, lawyers advocate for equity in maritime governance. Students analyze justice frameworks. They learn to balance competing interests. 4.3 Learning outcomes and competency benchmarks. By completing Law of the Sea, students should be able to navigate unclosed framework and institutional architecture. Analyze navigation, resource, and environmental doctrines. Address dispute resolution and emerging challenges. Advise on geopolitical, technological, and equity issues. Practical application, these outcomes prepare students for maritime law practice, government service, and international advocacy. Mastery ensures effective ocean governance advocacy. 4.4 Assessment methods, case studies, treaty analysis, and simulation exercises. Assessments include case studies, analyze ITLOs and arbitration decisions. Treaty analysis, evaluate unclosed provisions and related instruments. Simulation exercises, role-play maritime dispute resolution. Real-life example, a final project might involve advising a coastal state on managing overlapping EEZ claims, combining legal analysis, strategic planning, and negotiation. This mirrors real-world practice. Practical application, students should practice legal reasoning and advocacy skills. 4.5 Transition to capstone and beyond, Law of the Sea as foundation for ocean governance. Law of the Sea prepares students for the capstone project and careers in maritime law and policy. Capstone project integrates ocean law analysis in a substantial work product. Professional entry equips students to handle complex maritime matters. Global impact, ocean governance affects climate, biodiversity, and human security. Practical application, students should view the law of the sea as a critical framework for global challenges. Mastery ensures impactful advocacy for sustainable oceans. Slide 10. Year 4, Semester 1, Advanced Legal Practice. Course, Law.407, Legal Aspects of Business. Foundations of Business Law, Entity Selection, Governance, and Fiduciary Duties. 1.1 Business Entities, Corporations, LLCs, Partnerships, and Hybrids. Choosing the appropriate business entity is a foundational decision affecting liability, taxation, governance, and flexibility. Corporations, separate legal personality, limited liability, centralized management, but double taxation, C Corp, or pass-through, S Corp. Limited liability companies, LLCs hybrid features, limited liability, pass-through taxation, flexible management. Partnerships, general partnerships, unlimited liability, and limited partnerships, limited liability for limited partners. Hybrids and alternatives, benefit corporations, cooperatives, and series LLCs for specialized needs. Real-life example, a tech startup might choose a Delaware C Corp for venture capital compatibility, while a family business might prefer an LLC for flexibility and tax efficiency. The choice affects fundraising, exit strategies, and daily operations. Practical application, lawyers advise clients on entity selection based on business goals, risk tolerance, and tax considerations. Students practice comparing entity features and drafting formation documents. They learn to anticipate future needs in initial structuring. 1.2 Corporate governance, boards, officers, and shareholder rights. Governance structures define decision-making authority and accountability. Board of directors, fiduciary duties, care, loyalty, good faith, business judgment rule, and oversight responsibilities. Officers, day-to-day management, authority and liability. Shareholder rights, voting, inspection, derivative suits, and appraisal rights. Real-life example, in Smith v. Van Gorkum, 1985, directors were held liable for approving a sale without adequate information, illustrating the duty of care's practical requirements. Conversely, the business judgment rule protects good faith decisions. Practical application, lawyers advise boards on governance best practices, draft bylaws and policies, and represent parties in governance disputes. Students analyze fiduciary duty scenarios. They learn to balance managerial discretion with accountability. 1.3 Fiduciary duties in business contexts, loyalty, care, and good faith. Fiduciary duties are central to business law, imposing high standards of conduct on those in positions of trust. Duty of loyalty, avoid conflicts of interest, no self-dealing, corporate opportunity doctrine. Duty of care, informed decision-making, reasonable diligence, reliance on experts. Duty of good faith, honest belief in the corporation's best interests, not merely avoiding bad faith. Real-life example, in Goose v. Loft, Incorporated, 1939, the court held that a corporate officer who diverted a business opportunity to himself breached the duty of loyalty. This illustrates the strict standards applied to fiduciaries. Practical application, lawyers advise fiduciaries on compliance, investigate breaches, and litigate duty claims. Students practice analyzing fiduciary conduct. They learn to document decision-making processes. 2. Transactional practice, contracts, finance, and mergers and acquisitions. 2.1 Contract law in business, drafting, negotiation, and risk allocation. Business contracts allocate risks, define obligations, and provide remedies. Drafting principles, clarity, completeness, and enforceability, boilerplate provisions, indemnification, limitation of liability, dispute resolution. Negotiation strategies, identifying interests, creating value, and managing concessions. Risk allocation, representations and warranties, covenants, conditions, and remedies. Real-life example, in a merger agreement, representations and warranties allocate risk for unknown liabilities, indemnification provisions specify recovery mechanisms, material adverse change clauses allow termination for significant negative developments. Practical application, lawyers draft and negotiate business contracts, advise on risk management, and litigate disputes. Students practice drafting key provisions and negotiation simulations. They learn to balance protection with deal feasibility. 2.2 Business finance, equity, debt, and securities regulation. Businesses raise capital through equity, ownership, and debt, loans, subject to securities regulation. Equity financing, common and preferred stock, venture capital, and IPOs. Debt financing, bank loans, bonds, and mezzanine financing, security interests and covenants. Securities regulation, registration requirements, exemptions, Reg D, Reg A+, and anti-fraud provisions. Real-life example, in SEC v. W.J. Howey Company, 1946, the Supreme Court established the Howey test for investment contracts, defining securities broadly. This affects startup fundraising and crowdfunding. Practical application, lawyers structure financing transactions, ensure securities compliance, and advise on capital strategy. Students analyze financing documents and regulatory requirements. They learn to navigate public and private markets. 2.3 Mergers and acquisitions, structures, due diligence, and integration. M&A transactions combine or transfer business entities, requiring careful planning and execution. Transaction structures, asset purchases, stock purchases, and mergers, tax and liability implications. Due diligence, investigating targets' legal, financial, and operational status to identify risks. Integration, post-closing combination of operations, cultures, and systems. Real-life example, in Revlon Incorporated v. McAndrews and Forbes Holdings, 1986, the Delaware Supreme Court held that when a company is in play, directors must maximize shareholder value, illustrating fiduciary duties in M&A. Practical application, lawyers structure deals, conduct due diligence, draft agreements, and manage closings. Students practice M&A simulations. They learn to balance speed with thoroughness. 3. Regulatory compliance and risk management. 3.1 Employment and labor law, hiring, management, and termination. Businesses must comply with employment laws governing the workplace. Hiring, anti-discrimination laws, background checks, and independent contractor classification. Management, wage and hour laws, workplace safety, and employee benefits. Termination, at-will employment, wrongful discharge, and severance agreements. Real-life example, in Dynamex Operations West Incorporated v. Superior Court, 2018, the California Supreme Court adopted the ABC test for employee classification, affecting gig economy businesses. This illustrates regulatory impact on business models. Practical application, lawyers advise on compliance, draft employment agreements, and defend against claims. Students analyze employment scenarios. They learn to manage workforce risks. 3.2 Intellectual property and technology, protection, licensing, and innovation. Businesses rely on intellectual property for competitive advantage. Protection, patents, trademarks, copyrights, and trade secrets, registration and enforcement. Licensing, in-licensing and out-licensing strategies, royalty structures and field of use restrictions. Innovation management, R&D agreements, joint ventures, and open-source strategies. Real-life example, in Alice Corporation v. CLS Bank International, 2014, the Supreme Court limited patent eligibility for software, affecting tech company IP strategies. This illustrates the evolving IP landscape. Practical application, lawyers protect IP assets, negotiate licenses, and litigate infringement. Students practice IP portfolio management. They learn to balance protection with collaboration. 3.3 Antitrust and competition law, market power, mergers, and conduct. Antitrust law promotes competition and prevents anti-competitive practices. Market power, defining relevant markets and assessing dominance. Merger review, pre-merger notifications, competitive analysis, and remedies. Conduct, price fixing, monopolization, and exclusive dealing prohibitions. Real-life example, in United States v. Microsoft Corporation, 2001, the government challenged Microsoft's bundling of Internet Explorer with Windows as anti-competitive, illustrating antitrust enforcement in tech markets. Practical application, lawyers advise on antitrust compliance, represent clients in investigations, and litigate competition cases. Students analyze market definitions and competitive effects. They learn to navigate regulatory scrutiny. 4. Contemporary issues and professional preparation. 4.1 ESG and sustainable business, environmental, social, and governance considerations. Businesses increasingly address environmental, social, and governance, ESG, factors. Environmental, climate risk, resource efficiency, and circular economy practices. Social, diversity, equity, inclusion, and community impact. Governance, board diversity, executive compensation, and stakeholder engagement. Real-life example, the SEC's proposed climate disclosure rules require public companies to report climate risks, illustrating regulatory integration of ESG considerations. Practical application, lawyers advise on ESG compliance, draft sustainability reports, and litigate greenwashing claims. Students analyze ESG frameworks. They learn to integrate sustainability into business strategy. 4.2 Digital transformation, e-commerce, data privacy, and cybersecurity. Technology transforms business operations and legal risks. E-commerce, online contracts, payment processing, and cross-border sales. Data privacy, GDPR, CCPA, and sectoral laws governing personal data. Cybersecurity, data breach response, insurance, and regulatory obligations. Real-life example, in FTC v. Wyndham Worldwide Corporation, 2015, the Third Circuit upheld FTC authority to regulate data security as an unfair practice, illustrating cybersecurity's legal dimensions. Practical application, lawyers advise on digital compliance, draft privacy policies, and manage breach incidents. Students analyze technology law intersections. They learn to manage digital risks. 4.3 Learning outcomes and competency benchmarks. By completing legal aspects of business, students should be able to select and structure business entities appropriately, navigate transactional practice, contracts, finance, M&A, ensure regulatory compliance and manage risks, address contemporary issues, ESG, digital transformation. Practical application, these outcomes prepare students for corporate practice, in-house counsel roles, and entrepreneurial ventures. Mastery ensures effective business advocacy. 4.4 Assessment methods, transaction simulations, compliance audits, and strategic plans. Assessments include transaction simulations, draft and negotiate merger agreements. Compliance audits, evaluate business practices against regulatory requirements. Strategic plans, develop business strategies incorporating legal considerations. Real-life example, a final project might involve advising a startup on entity selection, fundraising, and IP strategy, combining multiple business law skills. This mirrors real-world counseling. Practical application, students should practice integrated legal business thinking. 4.5 Transition to capstone and beyond, business law as foundation for commercial practice. Legal aspects of business prepares students for the capstone project and careers in corporate law and business counseling. Capstone project integrates business law analysis in a substantial work product. Professional entry equips students to handle complex commercial matters. Entrepreneurial impact, business law enables innovation, growth, and value creation. Practical application, students should view business law as a toolkit for commercial success. Mastery ensures versatile and impactful practice.